this evening's meeting to order. Today is Tuesday, July 28th, 2026. This is a meeting of the Bridgewater Township Zoning Board of Adjustment. Adequate notice of this meeting was provided in accordance with the Open Public Meetings Act, NJSA 10-4-6, specifically on January 28th, 2026. Proper notice was sent to the electronic news sources of record, filed with the municipal clerk at the Township of Bridgewater, and posted on the municipal bulletin board. Please be aware of the Zoning Board of Adjustment policy for public hearings. No new applications will be heard after 9:30 p.m., and no new testimony will be taken after 10 p.m. So if you're able, I'd like you to stand and join me in saluting the flag. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ms. Probst, can I have a roll call, please?
May. Chairman Kulak.
Here.
Mr. Wadelli.
Here.
Mrs. Amin.
Here.
Mr. Fresco.
Here.
Mr. Franco.
Here.
Ms. Rose. Here. Mr. Gajewski is not here yet. Ms. Wiseman. Here. Mr. Vesio.
Here.
Mr. Colucci.
Here.
Mr. Mignella.
Here.
Richard Aller, Board Attorney.
Here.
Bill Burr will not be attending. Ms. Sarmad, Board Planner. Here. And Mr. Klein, Acting Board Attorney.
Here.
Oh, engineer.
Sorry, promoted him.
You got a promotion? Very nice.
I'm not sure that's a promotion.
Oh. Well, Mr. Klein, welcome. We appreciate your being here. Thank you. Well, let's see. We have, I'd like to open up the meeting to the public to address us on any matters that are not on tonight's agenda. So if you have a land use matter that you wanted to bring to our attention that's not on the agenda this evening, then you may do so. Seeing no one, we're going to close that portion of the meeting. We have minutes that we wanted to adopt from March 10th, but we had a little trouble in the printing of those minutes. We were missing a page, and then later when we referenced the transcripts, the reproductions of those transcripts were less than perfect, let's say. So we're going to try and redo all those things.
Make a motion to approve.
No, we're going to table it.
I prefer that we table it until we make all the corrections. So, Mrs. Amin, thank you for pointing them out. We were going to approve them with changes, but we felt that given some of the missing items, we'd prefer just to redo them and bring them to the next meeting. So thank you for that. We have at least one resolution that we'd like to have approved. It's application number 24-013-ZB. It's Sharif Shalabi, Block 374, Lot 9, 233 Shepherd Avenue. This is an extension of a prior approval. I believe Mr. Shalabi was at our last meeting, and his extension was approved, and we have a resolution to that effect. Mr. Oler, any comments about the resolution?
No, it's
I
accepted
don't have
as
any
is.
comments, so I will make.
Thank you, Mrs. Amin. And Mr. Oler, you have no comments as well?
No other comments, no.
Okay. May I have a motion then to adopt the resolution? Mr. Widley makes the motion. Do we have a second?
Second.
Mrs. Amin is offering a second. Can we have a roll call, please?
Chairman Kulak.
Yes.
Mr. Wadelli.
Yes.
Mrs. Amin.
Yes.
Mr. Fresco.
Yes.
Ms. Rose.
Yes.
Ms. Wiseman.
Thank you very much. So that resolution has been adopted.
The other one.
Do I have do I have another one? I thought
Roy resolution is good.
Shalabi, right? Oh, is that the, oh, I'm sorry, okay. So you also have an additional resolution. This is for Shai Amal Roy. and Shumei Roy. Application number 25015, Zoning Board, Block 164, Lot 402, Edgewood Terrace. So may I have a motion to approve this resolution?
I move.
Mr. Wiley has made the motion. Mrs. Amin is second. Roll call, please.
Chairman Kulak,
Yes.
Mr. Wadley,
Yes.
Mrs. Lamine,
Yes.
Mr. Franco,
Yes.
Mr. Fresco,
Yes.
Ms. Rose? That's all.
And do we have the application for CX Towers, the resolution for that?
No, we haven't received that transcript yet.
Okay, so we'll have that hopefully soon, and we'll be able to move forward on that. Moving to the next agenda items, we have two items on our agenda, one of which is just essentially a revote on an application, and having cleared up some technical aspects to this request, we're able to now look toward making a motion to approve a new D variance. So with that, we'd like to start with the Shaw application, and this is the second hearing. It's application 25-017ZB. And tonight we have, on behalf of Mr. Shaw,
Hi, Matt Flynn, professional planner.
Matt, welcome.
Thank you.
Have you been here before? I think you have.
I have.
Very well. Would you share with us your credentials?
Yes. Should I get sworn in first?
Yes, Matt, would you raise your right hand? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Education comes from Rutgers, master's degree in planning and public policy, professional planner's license in the state of New Jersey, as well as my AICP licensure, which is the national licensure for planners. Both are in good standing. I have testified before this board in the past, as well as over 100 other boards across the state.
Very well. We accept your credentials. Thank you. Tell us why you're here this evening and what you'd like to accomplish.
Sure. So if the board recalls, at the last hearing, the applicant came with a proposal for an outdoor patio. And at that time, the board requested additional information regarding the existing FAR of the existing single-family dwelling. So basically, we're here tonight to provide that information, to remind the board at the original hearing when he got his approval for the home itself, I guess it was, there was somewhat of an oversight in that these hillside development regulations should actually govern, which would modify the FAR calculation. So we've done that calc, and I am here to present the actual number to the board and to provide justifications for that variance as the board sees necessary.
Right. Now, this may be beyond your area of expertise, but I'd like to remind the board that at the time we heard this application, we approved it, and then we found out there were some technical issues, one of which you referenced, having to do with the FAR calculations, and so we asked that we rehear this. We also had some, what I'll call, back office issues to correct with respect to the certificate of occupancy, any other issues that needed to be cleared. And my understanding in talking earlier with Ms. Sarmad that those issues have been cleared, or I'm sorry, with Ms. Probst. Either way, I think they have been cleared. Yes?
Construction office confirmed by email that they had resolved all the code enforcement issues with the CO. So CO had been issued.
Great. Thank you very much for that. Mr. Flynn, would you continue, please?
Sure. So really the reason the applicant came back here for approval for variance relief initially, and by initially I mean at the very last hearing that we had, was for coverage related to the patio. The board granted that variance, again, under a condition that we come back here to present the proofs for the FAR, which I can testify to now is, given those hillside development regulations, it would be 0.16, whereas 0.15 is the maximum required. And just as a refresher for the board, the way that that works is on a normal lot with no slopes, the FAR requirement is 0.15. However, if you have slopes, basically that cuts into your lot area that goes into that calculation. So by taking into account those steep slopes and modifying the lot area, we ended up with 0.16, which is, again, 0.01 over the maximum of 0.15. I would note for the record that in my professional opinion, this actually wouldn't constitute a D variance, it would actually be a C. Typically, of course, as the board knows, FAR variances are D variances, but in terms of the municipal land use law, in terms of how how FAR is defined, just to give the board the benefit here, in the MLUL 40:55D 70D is what sets forth what a D variance is for FAR, and it is, quote, an increase in the permitted floor area ratio as defined in section 40:55D4. So when you go to that definition, basically floor area ratio means the sum of the area of all floors compared to the total area of the site. So in my opinion, and I think we can discuss this, I'm happy to put in proofs for either D or C, but just maybe for the board to consider in terms of any future applications or however the board wants to interpret that. I would think that that modified lot area calculation would constitute a C variance, seeing that it does deviate from the municipal land use law's definition of what constitutes a D variance.
Okay, so let's just pause there for a moment.
Yeah.
Mr. Oler, from a legal perspective, can you make sense out of that for me?
Yes, I understand what he's saying. He's saying under the municipal land use law definition of what is a floor area ratio, and the definition, it only includes the floors under roof, is his argument, right? So
Actually, what I'm saying is that the definition of floor area in the floor area ratio in the MLUL is the total lot area, and if the town decides to further modify that, it's getting away from that definition.
Okay, I thought you were going the other way. So, all right, so I can tell you in Bridgewater, we don't consider it that way. Never have. If you want, you are welcome to present a brief that we can then discuss it and we'll go over it at another time. But I would suggest you just do the
And that's fine.
for proofs.
That's fine.
Is we're not really, I don't see that we would proceed with that then.
And we have a particular value that we place on the steep slope ordinance and calculation, and so we don't want that to be eliminated from the conversation or the calculation. Ms. Sarmad, do you have an opinion one way or another? I don't want to put you on the spot, but I just did.
No, I know this has been raised outside of this application before I was here. I think it has been upheld previously, and, you know, the municipality's right to local zoning, which is constitutionally, you know, a power that the municipality has, means that, you know, the definitions within our code and the requirements within our code that affect different conditions do apply locally here. So you know, it has consistently been applied and required a D variance as a result of the hillside development calculations and its impact on the area, on the lot area. And so I would agree with Mr. Oler that it again be, the D variance be sought as it's been applied, you know, to numerous cases prior to this one.
Thank you. So with no further discussion, let's go down that road.
Absolutely. So basically, when we're looking at a D4 FAR variance, the test is whether the site can accommodate the additional building massing that we're proposing. As the board knows, the whole purpose of FAR in the first place is to provide a building that is proportional with the size of the property. It takes into account not only coverage or the first floor, but it takes into account those upper floors as well, and provides a requirement that puts that into proportion with the size of the lot. Here, I think when we're talking about whether the site can accommodate it, I would note for the board that we're talking about a de minimis deviation from that 0.15. I noted that it was 0.16, which basically constitutes 300 square feet over the requirement. On a compliant 40,000 square foot lot, you would be able to get upwards of 2,000 square feet over what we're proposing here. If the board remembers, we're dealing with an already undersized lot, so that's already an existing constraint on the property. If this were a 30,000 square foot lot, as it is now with no steep slopes, we would still be able to get upwards of over 700 square feet more than what we have now. So from a proportionality standpoint, the building massing that we're proposing clearly is not going to fly in the face of what's anticipated on a lot of this size.
Just so we're clear, the building mass has already been established as the building has been built. The application that came before us has no real impact on that. We're trying to do some cleanup, if you will, in getting the appropriate variances passed to support the building the way it is and to yet further approve or reapprove, if you will, or reinforce the approval we had made earlier for the application for the area, for the coverage.
Well said. Yeah, of course, the building is there. It got approvals. It's never good to have something that's not in the books. We want to have everything in record, both for the applicant's sake as well as for the town's sake. If something is a variance condition, we obviously want to know about it and have that clearly established. In terms of just justifying that FAR, I do want to remind the board again that we are dealing with a building that is compliant in terms of all setback requirements. So no matter which way you're looking at it, if you're looking at it from his right neighbor, or left neighbor, backyard, you're not seeing a building that is overly intrusive. So all of that, I would say, goes towards the negative criteria. The site can clearly accommodate that additional 300 square feet. In terms of the positive criteria, I think we can look to purpose A, promotion of the general welfare. It's home improvement. Of course, the home's there. It's a beautiful house if the board has seen it. It's right on line with what you see right across the street. If the board drove by or saw pictures, right across the street, there's 3 very consistently styled homes. Purpose G, variety of uses in appropriate locations. This effectuates a permitted single-family use, not only for this applicant, but for any future homeowner looking to live in Bridgewater. Purpose I, desirable visual environment. Again, this matches the aesthetic of what we have right across the street. Purpose M is efficient land use. And here, again, I talked about the fact that in a normal circumstance, the building massing would be allowed to be substantially higher. And again, when we look at what's happening right there, we see something that is right on par with what's happening in the neighborhood. If the board remembers, and I don't know if I have to go into the proofs for the coverage, I think that was put on the record at the last hearing, but again, just to reiterate.
Mr. Oler, I think we can subsume those two things together, and we're not true.
Well, no, but we've already heard all the proofs for lot coverage and height, so I think we're
Right, yep,
we're good there.
okay. So I think that pretty much sums it up. I think this is an appropriate application. I know the building's there, but even if it weren't, and we were talking about this from scratch, I think there's a lot of things that the board could look at in terms of what makes this building massing appropriate for the property itself as well as the surrounding area.
Let me start with Ms. Sarmat. Do you have any questions for our witness with respect to his planning testimony and his request?
No, I believe Mr. Flynn has put on all the necessary proofs for the D4 variance. As mentioned, the first hearing really went through the majority of what was actually applied for.
Yes.
This D4 variance was something that ended up kind of as a condition of that action by the board, which is still open as part of this case. And it's unusual what happened, but I appreciate that the applicant has gone through the exercise of, calculating the FIR, showing it on the plans, undertaking the hillside development calculations as required by our ordinance, and then coming and seeking the D4 variance as necessary. So if you notice the review memo, the joint supplemental review from Mr. Burr and myself, really didn't ask too many questions because I think this is really something that's already been hashed out at the first hearing and is just a result of them going through the calculation. We wouldn't be here if they had gone through that calculation and found out that there was no FAR variance. Right. It really is a function, I believe, of the hillside development calculations having an impact that may or may not have made it onto the plans when they went to the building department. So I appreciate that they've come back. I appreciate that they've put on the proper testimony and that they're seeking the appropriate relief.
And I think from the point of view of all homeowners, when you have the opportunity to come before a board and you kind of clean up all of the open items that may impact your ability to improve the property in the future or transfer the ownership of the property by coming to us proactively, even though it was in concert with making an application for some improvements, you really put yourself in the best position to do all those things. Any members of the board have questions for Mr. Flynn and his testimony?
What year was the home constructed again?
2022.
Is the contractor in the audience tonight?
Mr. Vesio, you done?
Yes.
Are you looking for something that I can't discern here?
I certainly don't fault the homeowner for this, and I think, give him credit for correcting the item.
Okay, thank you.
With a home constructed in 2022, it's surprising that the lot coverage was exceeded, the height of the home was exceeded, and the FAR was exceeded. And I think it's certainly the responsibility of the design professional to have not permitted that and provided a compliant design for this home. So,
And we are nonetheless talking about it, as Mr. Flynn described, a de minimis difference, but it's best to address it now while we have the opportunity to do so. Any other questions from members of the board? Seeing none, I'm going to ask if there are any members of the public who would like to question Mr. Flynn with respect to his planning testimony only. And seeing none, we'll close that portion of the meeting. And Mr. Oler, you want to walk us through what is required of us at this point?
Yeah, so I'll just remind the board that we heard the first part of this case on March 10th. The board actually voted to approve the improved lot coverage variance and the height variance. And at the time, it was going to be a condition of approval that the FAR information be placed on the zoning chart. And if it turned out that you needed an FAR variance, you'd have to come back. Before we adopted that resolution, the applicant did the calculation and said, hey, guess what? We need an FAR variance. So as a result, we never adopted the resolution.
Right.
So this evening, what the board, I would like the board to do is then we're going to revote the entire application for improved lot coverage, the FAR variance, and the height of the building. And based on the testimony that we heard not only tonight, but on March 10th, and I'm just looking for the conditions, just as a reminder, the conditions then, well, obviously the condition with respect to FAR would go away, but the applicant would have to provide an engineer certification that no NJDEP permitting is required for some of the activities that were on the site. There'd be no spotlights added to the property. They'll confirm with the township engineer his satisfaction of the stormwater management plan. They were going to provide a perk test and location of seasonal water table prior to issuing the permits. Although I think there are no, that's wrong. Oh, we're right? Okay. Right. Right, and you're going to add an additional chamber if required by the township engineer, right? So those were the conditions.
So with that, I'd like to have someone make a motion to approve, well, I should allow some deliberation.
I would deliberate.
Yeah, I'm sorry. So any board members would like to discuss this, we can do it in order if you'd like. Why don't I start with Mr. Fresco?
Interesting choice, considering I'm the one nay on this,
Right.
On this application.
That's why I asked.
Yes, thank you. So I feel the same way. I really do, and I think that
Okay.
this brings to light what my concerns were then, that it's just a little too big, and it didn't need to be that big. So that's my feeling, and just I'll stay consistent.
I appreciate you doing that. Mrs. Amin, do you have any comments or?
Yeah, the difference between what is required and what they have is only 265 square feet, which is very small. And in my opinion, it should not have any impact on anything. And I'm in favor of approving this application.
Thank you. Mr. Franco?
I have no issues with this application.
Thank you. Mr. Vesio?
I would support this application because the homeowner is coming here and looking to kind of right a prior wrong. And I don't want to create a precedence that sort of scares away residents from not going the proper path for such conditions. So we certainly want to encourage residents to go through the proper permitting process. I just would maybe make a comment to our, building and code office to really scrutinize any future designs submitted by the permittee in this case to make sure they are truly code compliant. Inspections cover the same thing to they follow the plans that are submitted because this is a very new home. But I'm in favor of it. Thank you.
Thank you. Mr. McNally?
Excuse me, it seems that we're just approving both the new project is, to me, it's not all that big that it's affecting the overall look of this house on that property, the proportion, and we're correcting an oversight from the past. The homeowner shouldn't be penalized.
Very well. Mr. Wisely, would you like to comment?
Yeah, I have no problem with the application.
Ms. Rose? I have no problem with the application. Johanna? Ms. Wiseman, sorry.
I do, thank you. I am concerned that, I feel that the builder did a disservice to this homeowner by delivering this home that exceeded without warning the homeowner that they would face a big challenge with adding the outdoor things. So I would not want to see that again. But in this case, because they've been so diligent and because it's a very small margin, I would approve.
Mr. Colucci?
I'm good with it.
I too would support this application. I think that given the homeowner's ability to come to this board and to try and clean up things that had been existing in the past, along with some of the new issues that we addressed at the last meeting and this meeting, I would support this application as well. So I would like someone to make a motion to approve this application.
I'll make it.
Mr. Widley
Approve this application.
and Mrs. Amin has seconded. Nancy, may we have a roll call, please?
Chairman Kulak,
Yes.
Mr. Woodeli,
Yes.
Mrs. Amin,
Yes,
Mr. Franco,
Yes.
Ms. Rose, Ms. Wiseman,
Yes.
and Mr. Vesio.
You missed Mr. Fresco, I think.
Mr. Fresco voted.
Oh, you got it?
Yeah.
That's all right.
Yeah,
Well, since we had a no.
No.
I apologize. Mr. Fresco's no. Okay.
Everyone else is covered in terms of voting?
Ms. Wiseman?
3, 4, 5.
I voted yes.
Yes, that's 7.
Thank you, board.
Okay, I'll have that for the next meeting.
Sounds good.
Very well.
All right, have a
Thank
good
you,
night.
Mr. Flynn, appreciate it. We're going to move right into the next case. Yeah. We're going to be moving into our next case, so for members of the public
other two variants.
who are here for application number 24-029ZB, Rockland APV Bridgewater Energy LLC, Block 338, Lot 9, otherwise known as 760 East Main Street. We're here to continue their application. This is our third hearing on this matter. And we'll be getting started shortly. You guys, if you need a few minutes to get yourself together, that's fine. Is our applicant ready?
Yes, we are. Thank you very
Great,
much.
thank you very much. We appreciate your patience. I know that you're trying to get as much done as we are, so we'll move on. Mr. Oler, do you want to set the stage for us?
So the board has continuing jurisdiction since the meeting date was previously announced. I believe this evening, Mr. Pantel has indicated that he's going to do civil engineering with Mr. Stiers, and he has his fire safety expert, Mr. Dianar.
Yanarine.
Okay. And I think those are the only two subjects we're covering this evening.
Correct.
Right? I do want to point out to the board that there was a recent case about 2 weeks ago called Monarch Communities versus the Township of Montville, which impacts inherently beneficial uses, and the applicant's making an argument that this is an inherently beneficial use. Tonight's not the night for that because his planner's not here. We're going to get to that point. Prior to that, will provide the board with a memo with respect to the Monarch case and what it says about specifically referring back to the second prong of the negative criteria and doing that before you start the SICA balancing test. But I'll outline that for the board. I just don't need to do it now because it's not something that we're going to do tonight.
Yeah, agreed. Yes, needless to say, we're familiar with that case
Yeah.
as well, and we will address it in due course.
And that decision was a recent one.
Yeah, 2 weeks ago.
Right.
Right.
Thank you.
Right. And just on that point, Glenn, I know you submitted a memo with respect to, why this case is inherently beneficial. I don't know, it's up to you if you want to supplement that as well. I do intend to do a summary to the board, not just for your case, but just in general for all future inherently beneficial uses and how the board should be addressing those and specifically deliberating on those.
Yeah, no, I do appreciate that. We can certainly supplement the memo as appropriate, though the memo that we did submit goes to the notion of classifying the proposed use as an inherently beneficial use. It did touch upon the criteria, but the main focus was the use should be treated as inherently beneficial, which I think is still advantageous to an applicant, but you're correct. In light of this case, we do anticipate that we would supplement what we did previously submit to the zoning board.
Yeah, because now we have to talk and look at the second prong and, what the impacts are to the master plan and zoning, right, before we even get this.
Exactly, and as I say, we're not going to go down that road tonight. We have a number of things to say about that, as you might imagine, but we don't need to go there this evening.
Agreed. Okay.
Very well. Mr. Pantel, I know you're going to be asking Mr. Stiers to offer some additional testimony. Did you have an opening statement or something you'd like to share with the board?
Just very briefly, to refresh the board's memory, for the record, Glenn Pantel with the law firm of Faegre Drinker, Biddle and Reith, attorneys for the applicant, Rockland APV Bridgewater Energy, LLC. So at the two prior hearings, you heard initially testimony from John Seeker, principal of the applicant, project manager, regarding the nature of the proposed facility. You heard how it ties into the grid, the various benefits it poses in terms of utilization of renewable energy and increasing the resiliency of the grid. Not a small benefit in the sense that this project is sizable enough to support 20,000 homes for 4 hours of normal electricity supply. We also heard from Joe Brown with Trina Solar, which will be the supplier of the product here. Mr. Brown is very experienced and expert in the area of energy markets, energy regulation, and of course utilization of the proposed BESS facility. He did touch upon some of the safety issues that had been questioned by the board, including the fact that Trina Solar has put in place some 250 comparable facilities without any fire episodes. But you'll be hearing tonight from Leonard Dianorine, assuming we get through Mr. Stiers' testimony. Mr. Dianorine is prepared to respond to the the first item that had been raised by the board with respect to fire safety, namely a question had been raised concerning an incident that occurred in Arizona a number of years ago, and he submitted a report addressing that and in distinguishing why it should not be problematic for this application. Also-
Just to interrupt you for just a moment, with respect to his response to that particular case,
Right.
the board and the public in general continues to read about similar fires in a variety of locations, some of which are far more recent and far more local, as in New York itself, in the state of New York. So we're not going to limit our inquiry just to that one
No,
particular
by
fire.
no means. And in fact, your Environmental Commission raised a few other incidents that we're in the process of preparing another report to submit to the board. So it's not going to be, I do not anticipate that his testimony tonight will address those 3 or 4 other incidents raised in the Environmental Commission report. But in the interest of moving things along, and in the interest of addressing the report which he did submit regarding that Arizona situation that was initially raised, he is prepared to address that, as well as his emergency response plan, which was submitted about a year ago to the board.
Great, thank you.
Okay? Thank you. So that said, I'd like to start off with Mr. Stiers, and he has not testified previously on this application, so we'd have him introduce. He's the project engineer, of course. I know he's been before this board. Why don't we have Mr. Stiers sworn, and he can address his qualifications briefly.
Thank you, Mr. Stiers. Would you please stand and raise your right hand? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth? Yes, I do. And your full name for the record, please? Frank Stiers. Thank you.
You're going to have to talk into that microphone. I apologize. You'll have to share it, but
Sure, no problem. So could you please summarize for the board your experience as a licensed professional engineer in New Jersey, and including, of course, your experience in testifying in Bridgewater?
I am a professional engineer in the state of New Jersey since 1993. I have been testifying before this board pretty much since that time, dozens of times for various applications, including residential, commercial, industrial facilities in Bridgewater, as well as throughout central New Jersey.
And Mr. Stiers, is your license in New Jersey current?
Yes, it is.
Thank you.
very well. We accept your credentials. Welcome. The floor is yours.
So could you please describe for the board the nature of your involvement in this application, providing an overview of the application, the various variances that are implicated with the application, and as well as addressing the reports and comments that we've received from the Township Engineer's Office?
As far as my involvement in the application, obviously we were retained to do the survey and site plan for the application for the best system. It's the site plan that you have before you. We also did the limited environmental impact statement, as well as the stormwater report that was part of the project. I can just go right into the site itself. It's located at 760 East Main, otherwise known as Lot 9, Block 338. It's on the southwest corner of East Main and Paul Hemus. That's right now is currently the entire tract is utilized for storage of vehicles associated with Somerset County. There's currently a stone lot there. If you recall, before that, it used to be a roadway truck transfer station. So it was essentially, you had loading docks on both sides, and trucks came in and shipped from one side to the other. Probably a substantial amount of trucks in and out from that facility. From that time, the county bought the property and is currently using it as it is today. One thing to note also is when the Route 22 Chimney Rock interchange was completed, because Route 22 was cut off, or the quarry more so was cut off from the rail going into the quarry, what happened was they created this site as kind of the transfer of the stone materials for the quarry. So what would happen is the rail would come in and stop at this point. They would unload the rail, the stone would be piled in the, pretty much where the best system is proposed, and that's why you have the stone in that location. From that point, the trucks would take that stone into the quarry and vice versa. So the stone would come out of the quarry into the rail and be distributed out off the rail. The trucks came into the facility. The small driveway that goes up into what is shown as the best system is where the trucks came in and out, loaded, unloaded. There's a 30-inch pipe that's underneath there. That pipe took all that, the truck traffic back and forth, and is still in good condition. So that's kind of
The current condition is that the rail line has been extended across 22 all the way up to the quarry, so the need to transfer the stone material is not present at this time?
Right. Once the interchange was completed, everything back to normal. And
Right.
What is left there now is the kind of the remains of the loading and unloading, which is the stone.
Right.
And if you were to see the berm on the property, that is the topsoil that was removed to put the stone down.
So is there, what will you be discussing this evening then, a plan with respect to that stone, whether you've looked at it, evaluated it, and so on? Is that part of your responsibility this evening?
As far as what?
Whether it's clean fill, whether it needs to be evaluated further?
I don't believe that it needs to be evaluated further. It's just the material that was brought in and out and used as construction materials.
Right. Well, you said you're also going to be talking about an environmental impact statement. So
I said we prepared the environmental impact statement,
you won't be discussing it this evening?
unless there are questions about it.
Okay. So what I'm asking right now is the material which was transferred, has it been tested? Should we require it to be tested? Does the DEP need to look at it? Because all of those areas, they were, when Roadway Express was there, you had a lot of trucks moving in. You have dilapidated trucks parked on that site currently. There's an opportunity there for some kind of seepage, leakage, and so on. So I'm asking you if you're going to be testifying to any of those things, or if that's something we need to do separately.
I am not testifying to that. No.
Okay. You may continue.
Yes, could you comment on the surrounding uses, please?
The surrounding uses are obviously to the west would be the Somerset County Maintenance Yard. To the east across Polhemus is the PSNG substation. To the south is, I believe it's Joe Horner's facility. So he has, I think it's related to the truck and dumpsters.
I'm sorry, you think or you know?
I know.
Okay.
I just don't know the name of his business, but that is immediately to the
So you're naming an individual. We can find out the name of the business, or Mr. Pantel can find it out for us. And you're referencing that just to describe the site?
I'm describing what's around the property.
Okay, continue.
And then further to the south is there's a lagoon with contaminated material in it. And then across Polhemus is the truck or the transfer station for the garbage.
And that lagoon is part of the American Cyanamide Superfund site now under the management of Pfizer?
I don't believe so.
It is.
It was in a cell that was to the west of the roadway going to New Jersey American Water. So that was excavated out, mixed with fly ash, and put into this particular lagoon.
Right, and I would ask somebody to, perhaps yourself, to validate with American Cyanamide, now that site's being managed by Pfizer, as to whether that material is theirs or who's responsible for it.
We can address that at a subsequent meeting.
No, I appreciate that. It's just, you're asking us to evaluate the entire project. You're describing the site. When Mr. Seeker was here earlier, he was describing the site selection process, and every one of his criteria related to the efficiency of the operation, the profitability of the operation, how much easier it is to connect when you're close to a substation. all of those criteria were read into the record, but not one of them mentioned safety in any way. I know Mr. Fresco brought up alternate locations, and I think it was Mr. Fresco who asked him about the site selection process. And he was very forthcoming in his analysis. But it didn't include the things I'm looking for, or I think that the board is looking for in the whole. So that's why we're bringing it up.
Yeah, we can certainly respond to that. I don't think we need to divert right now from Mr.
That's okay.
testimony, but
I just want to make sure we're being thorough.
yeah.
Mr. Stiers, you want to
I
continue?
can't tell you, it's my understanding for that sort of thing, not as a substitute for future testimony, but it's my understanding that what's been alluded to is not impacted by the proposal, and those situations are not controlled by this site and should not be affected by this proposed development. But we'll have additional testimony on that, not a problem.
Right, because it is a adjacent property, a neighboring property, we have to look at what happens if scenarios and what happens if we've got a lot of complicated issues there. So, Mr. Stiers, continue, please.
Okay, can you discuss the characteristics of the site and its sizing?
The proposed?
The proposed site, yes.
So what we're proposing to do is to subdivide the property into two lots. Lot 9.01 would be 4.23 acres. Lot 9.02 would be
902 is 2.89.
I'm sorry. Yes, 2.89 acres. Sorry about that.
And lot-
Maybe you could just restate that because we're having trouble following you.
Lot 9.01 is 4.23 acres. Lot 9.02 would be 2.89 acres.
Okay.
And the lot 902, the smaller of those two is the lot on which we're proposing the development.
That is correct.
Okay.
And what's the minimum lot size required in this zone?
20 acres.
I'm sorry?
20.
20 acres? And you're saying that the site as proposed is how many?
In total, it's 7.13 acres.
That's in total. And the site that you'll be developing is what size?
2.89.
2.89 compared to required would be 20.
Yes.
Okay, continue.
As far as the lot width is concerned, Lot 1 would be 254 feet, and 500 is required. Lot 9.02 is 203 feet, and 500 is required. And again, what we're looking to do is to subdivide the property, and then Lot 9.02 would be the property is being developed with the best system. The system would be proposed in the southerly end of the property.
You want to point that out on your drawing, or maybe we can see if that drawing has been admitted as an exhibit?
Yes,
I don't think it
that drawing
has,
been
right?
marked as Exhibit A3.
That's been marked?
Yes.
Okay.
This was on the computer, I think, at the last hearing, but we have marked it as A3.
The same as what was presented on the computer.
So again, this is A3. Oh,
Sorry, Glenn, so the face of that exhibit has a marking on it as A3?
yes.
Okay.
Again, this is the entire tract which is shown. You have East Main Street, Polhemus along the bottom. It is 7.13 acres in total. We have currently the stone lot in the front, which is where the county keeps their vehicles. The back half is vegetation. This is the area that I mentioned in the beginning about this stone and the loading and unloading. There is a berm here, which was the topsoil, which is stripped to put the stone down when they were doing that. And ultimately, like you said, they completed the interchange and went back to what they were doing. There is a waterway that goes through the property and ultimately discharges into the storm sewer at the intersection. We do have an approved LOI for that drainage way. It was determined that it is a ditch, not a state open water. So they pretty much assigned a wetland area in this location, which is on the east side, with a 50-foot buffer. And since the drainage way is considered a ditch, with regards to flood hazard, there is no riparian buffer.
So for the benefit of the board, you're using ditch as a technical term,
Yes.
okay? And could you define that so we understand it?
It's essentially, it was man-made. So if the drainage way were considered a state open water, then it would have a riparian buffer associated with it. So the DEP categorized it as a man-made ditch, and since it's not a state open water, it's a man-made ditch, there is no flood hazard riparian buffer associated with it.
And that ditch, as you call it, drains into a storm sewer on which street, Polhemus?
It's pretty much right at the intersection of East Main and Polhemus. So this is where it's picked up. So it's overland and picked up into a pipe.
And it's taking water from the site as it's currently being used by Somerset County and will be used by your proposed site as well?
Yes.
Okay.
Could you comment on change, if any, in the drainage pattern resulting from the development?
The drainage pattern would not change. And in fact, we are removing a lot of the stone in the proposed BESS area, as well as some stone that is in the front of the facility. So there's going to be a net decrease in impervious coverage as far as the overall project.
What would that decrease be? Can you take a look?
I believe it was about 30,000 square feet.
Decrease in coverage.
Correct.
How do you know that's man-made ditch?
Excuse me?
How do you know that's a man-made ditch? How did you come to that determination?
The DEP determined that.
So that's a deed,
They did, we submitted, one of the, our clients' consultants submitted for an LOI, a letter of interpretation. They submitted all the documentation as far as, soil samples and things like that. And they came back and the DEP made the determination that it is a man-made ditch.
It looks, just orient me again, where's Polhemus in this diagram?
Polhemus is
Right.
on the bottom. East Main Street is on the right-hand side.
So as that ditch drains, you were saying it almost comes out to the intersection of Main and Polhemus?
Yes, the
Okay, gotcha.
pipe where it goes into is right at the intersection.
Right. And so the area of that ditch that appears to be wider, I guess that's at the eastern end of the property?
Right through here?
Yeah.
Yes.
Can you estimate how big that is?
Probably about 30 feet wide, maybe 75 feet long.
And that's still a ditch? It's not a pond?
They did determine this area to be wetlands.
Okay,
So the flagging through here, that would be out when they delineated it. They did determine this to be wetlands, so this portion does have a 50-foot buffer on it.
okay,
The drainage way through it is a ditch.
gotcha.
so on the top side there, then I guess that's the west side of the property. See, there is, looks like a storm sewer that drains into that ditch. I see the number of inlets coming off that as well.
From the county facility, which is, this is the county maintenance facility. So they have their improvements, the parking lot in the back, and that drains into the ditch and ultimately through there.
And there's no drainage above the county facility that's kind of making its way into that system?
I believe that's the only thing, because you have, I believe there's another roadway on the west side of the county facility that I believe picks up and probably goes towards East Main Street.
You can continue.
Could you comment on the the side yard and rear yard dimensions as well? Yes.
Okay, for lot 902, the front yard setback is 87.7 feet proposed, and 150 is required. Side yard setback is 24.15 feet and 39.5 feet, and 75 is required. Combined is 63.48, with 175 being required. And the rear yard is 41.23, and 100 feet is required.
Could you orient us as to the side, front, rear, et cetera? Because you have a corner lot there, which makes it, from my perspective, a little more complicated, but maybe not.
I believe for a corner lot, it's two fronts, so really it would have one side. So you have front, I'm sorry, this is not a front because it has the rail.
Yeah, exactly.
So the rail, there is,
If I could, just for a second. Not a corner lot because...
Mr. Pantel, would you speak into the microphone,
Yes,
please?
absolutely. Not a corner lot because along Polhemus, the lot is separated from Polhemus by a fee-owned strip a fee simple strip owned by the railroad. So we do not actually have frontage on Polhemus. So
Okay.
the only street frontage that we have adjacent to the property is on East Main Street. So we have a front yard on East Main Street.
Right.
And then take it from there, Craig.
so to clarify, the rail property is in this location right here. So you have Polhemus Rail, which is a fee-owned, as Glenn said, and then our property.
Gotcha.
So therefore, it's not a corner lot. So we have front, side, and rear. Sorry about that.
Great, thank you.
Okay, let's proceed. Can you tell us a little bit about the proposed operations of the project? Actually, though, before we do that, one point I'd like to make regarding the variances, and obviously we'll be presenting testimony from a land planner on the variances, but as we've heard this board address in the context of at least one other application, typically the bulk variances can be subsumed within a use variance if a use variance is approved, because obviously ordinance provisions weren't tailor-made for, and bulk provisions weren't tailor-made for this specific use on the property.
I almost heard everything you said, but you and I are the same in that we like to look at each other when we talk, but then we walk away from the microphone a little bit, so I'm not sure that it was heard.
Okay, sure. The point I'm trying to make is that I wanted to keep eye contact.
I understand.
But there's also mic contact about that. But in any event, as we've heard this board say, at least in the context of one other application that we observed, it is consistent with case law to recognize that various bulk variances are actually subsumed within the grant, assuming it is granted, of a use variance, because ordinance provisions addressing a use that's not a permitted use on the property typically are not tailor-made or geared for that specific use. That said, we obviously want to be completely transparent with respect to what's going on with the bulk provisions, and we'll have planning testimony that addresses that. I think the point for Mr. Stiers is that given the configuration and size of the lot as it now exists and then as subdivided, can the lot safely and reasonably accommodate the proposed use on the property?
Based on what is proposed on the lot, yes.
Okay, so could you proceed, please, to describe the
I just want to give Mr. Oler an opportunity to consider what you said from a legal point of view, see if you have any question.
I do agree that in many, but not all, instances, bulk variances can be subsumed within a D1 variance. And I say that because sometimes, the bulk variance would be applicable anyway, no matter the zone. But in this case, we have, lot area, lot width, front yard, two side yards, and a rear yard. To me, those are the types of variances that would be subsumed in a D1.
Thank you. Yeah. Sure.
So one last thing with the existing property is that we have delineated on the plans this dark line, which is essentially this northeast corner of the property is the flood hazard area. So that's related to the elevation of the waters based on the flood hazard. And this line is based on the current rules, which is, I guess, implemented in 2023 because the other ones were retracted. Anyway, so what it is, when you look it up, the DEP has a elevation for the Cocos Brook, and that is 45.4. And what the 2023 rules are, you have to add 3 feet to that. So that's where this elevation of 48.4 is shown on the plan. So again, the project itself is not affecting that. We are removing some stone that is in the area of the flood hazard area, but that constitutes a permit by rule because we're not changing the grade. We're actually making things better by returning it to a vegetative state. And a permit by rule, you won't have to submit to the DEP. And there's a whole list of permit by rules and the regulations, and we fall in that one of those categories.
So could you?
One of the questions it poses for us, though, being laymen, is does the lot flood? Because right across the street is the substation, and they've recently made application to elevate all of their critical infrastructure beyond the flood. That would be the PSE&G one across Polhemus. So I'm asking in practical terms, not in whatever you just said, but does the lot flood?
A portion of the lot does flood in the northeast corner. However, where the facilities are proposed, they do not. For example, the batteries are elevated well above that elevation. And then these are essentially like metering small.
Well, that's like two different answers. So the batteries are elevated because water gets underneath them if they're not?
The ground elevation is substantially higher than the flood elevation.
Okay, go ahead.
What is that ground elevation?
I believe we're in the mid-50s in this location, and then, like I said, the flood hazard area, the 3-foot buffer is 48.
And you're speaking in terms of the maps that were issued in 2022, then you kind of digressed a little bit. So is that the most current one that everybody needs to adhere to with the 150-year storms and things like that? Or is it something different than what we're used to seeing now?
What was implemented in 2023 by the...
Are you asking me? Because I don't know. That's why you're here.
I'm telling you.
Okay.
Implemented in 2023 by the Department of Environmental Protection.
That's what you're guided by.
Yes.
Okay. Mr. Fresco, did you have a question?
Yeah, just to stay on that. So show me the access road, the service road in relation to the flood area. Where do those, are they near each other? Looks like,
It follows on either side of the ditch in the location just below. So this is the current stone driveway with the 30-inch pipe
right,
underneath it.
yep, I see it.
This would be the access to the system. That flood elevation essentially goes to that downfall, the outfall of the pipe.
So the road floods or it doesn't?
Does not.
And the
But it's
access
close.
point likewise does not.
And the access point to the site does not, no.
Right, the access, and that's exactly, right. That green box right south of your finger, that big green rectangle, is that the flood? What is that big green?
This line right
Yeah.
here is the flood hazard limit.
Right, so it's also it's near the entrance as well?
Theoretically speaking, that is the number with a 3-foot buffer. I have spoken, my brother has a facility on Raynell Avenue, and I spoke to him regarding this, like, for example, Ida and the intersection. And there was very little flooding, believe it or not, in this intersection. I've also done some work for the former restaurant on the corner here. They said that there was water on the property, but the buildings did not flood. So it kind of gives you a frame of mind. And Ida was a pretty good story.
You're talking
Yeah,
about
no,
Ida.
Yes.
You know, I hear you, but, I mean, it's not hard to imagine that if that road floods and something happens at the same time, we might not be able to get a vehicle to service the units. I mean, that's how these tragedies kind of happen. It's just like, oh, that happened, then that happened, then that happened. Just throwing that out there. That's where I'm thinking. You know.
Again, we're also talking about
Excuse me for just a second, Mr. Stires. Members of the public, there will be an opportunity, not just yet, please. There will be an opportunity for you to ask questions about his testimony, and probably in a short period of time, but if I could ask you to hold them until then? Yeah, thank you. That's okay. Continue.
We anticipate getting an easement over the remaining property, which would get us to the the driveway for Somerset County, which would be further up above the flood elevation.
Okay, thank you.
Are there, Mr. Stires has been testifying. Did the board members have any other questions right now before we ask him to continue?
That was all I had, just because it was relevant.
No, I appreciate it. Continue, please.
Yes, can you proceed to talk about the nature of the operations on the site?
Sure. Based on, and again, I think there's been some testimony on this prior, the facility be 24/7, be manned remotely, and it's expected to have roughly three employees for maintenance purposes that would visit the site maybe once a month, just to look over the equipment, make sure everything's functioning properly. We have not proposed any type of parking. What is expected is that the people that would come into the loop drive here and just park right on the driveway. That way they're proximate to anything that they're looking at and that needs maintenance. So there is really no dedicated parking per se.
Can you address security, please?
It is anticipated, while the site is currently fenced, we are going to put new fencing up around the best facility, so that would be fenced individually, and a gate at the top of the existing driveway. And then the metering equipment would also be gated and fenced. The fencing out there would be removed, and we would put fencing in similar to what is around the PSE&G facility. So it's got a thicker gauge, and the openings are much smaller.
I think they're going to be changing that as well under their new plan, but that's something to be considered because they just were before the planning board not too long ago with the new design. Security, of course, on this site is going to be an issue because you have so many unfettered access points from the Somerset County the transportation offices, the ins and outs of the garbage facility that's back there. If you put up a fence around the best containers themselves, that's a help, but I'm not certain that it meets the needs. But I'm not sure that that's what you're going to talk about right now, so.
But again, it's the best will be fenced in.
Right. Yep. I'm thinking of things that are more nefarious, somebody entering the site in a vehicle that just runs right through the fence, which is not a big deal to do. So I think security is an issue that we need addressed. I'm not sure when you talk about what you're proposing, if it's adequate, maybe we need some additional information. I can't tell from what you said whether it'll be adequate or not.
I'm not sure as far as the security, what you're asking. Is someone...
Because people will have access to the site either from the Somerset County parking or truck facility, transportation facility. There's a garbage operator that has access to the site on the, it would be east of your property in the southernmost corner, southeast corner.
There's also a rail that...
Right. I'm not concerned as much about that, although you're so close to the road that I could be concerned about that.
and then there's fencing
Right.
around the...
Right now, I could drive into the Somerset County Transportation Office and walk all over the site. Nobody stop you.
What will the fencing do, though?
Our fencing would prohibit access from
Right.
the main facilities.
Correct. And when you say the main facility, you're saying I can go up to the fence and look in, and that's it. And I'm saying that if I'm driving a vehicle, I could knock down your fence.
I'm sure anything's possible.
Anything is possible. It's just we've had terrorist incidents on the West Coast where they came into a substation and did exactly that. Just drove through the fence. The only thing that stopped them was they ran into a reel of wire that stopped the car. So today's world, we're security conscious. I'm just not certain that your fence is going to be adequate. But we'll ask the board to weigh in on some of these additional questions, and we'll get some additional information that we might share.
Right, and we may be able to, now that we're hearing this sort of concern and question, we may have some additional things.
Right,
to
it's
say.
quite possible.
We could look into that.
Let me, I'm sorry, Mr. Stars, you can continue if you'd like to.
Yes. Yeah, please do. So there were various questions that were raised in the reports that we received. Can you talk about the lighting?
Right now, we show lighting because it's really more of a checklist item as far as the site plan is concerned for, in Bridgewater. If there are concerns with the lighting, the applicant doesn't really need the lighting. So one, we can remove the lighting, or two, we can put not even on timers, but more of a switch. So when someone needs to get into the facility and work on the facility, they can literally just turn the lights on, if that is a concern by the board of light spillage and what have you.
Okay, so we'll stipulate that we will be able to comply with applicable ordinance and spillage requirements?
Yes, because right now, the only spillage that we have is really just in the driveway. So it's in this area right in the driveway. We could lighting and, when they want it on.
Well, I'm going to ask the board professionals to weigh in on the lighting specifically, unless the board members have questions.
Sure.
Any other questions? I'm not going to cut you off yet, but any other questions that have come up?
Yes, Chairman, I have one question. It's not a fire question, but I understand with battery fires, a large volume of water is generally needed to put out such fires. I guess we'll ask it to the fire person, fire expert here. But with a large, let's say, and we'll ask the question to the next witness, and whether or not that water would end up being contaminated or not contaminated after putting out a potential fire. We'll ask that question as well. But where would the water go at that point? The water used to combat the fire, would that go into the ground?
I think we should defer that to the fire expert, and we can always have Mr. Stiers respond further if necessary, but our fire expert has looked into that very issue that you're addressing, and he's here tonight.
Okay, because the question is more of an environmental question, not so much kind of a fire question.
Well, I think one of the things you'll be hearing is that this, and consistent with the emergency response plan, is that this is not the sort of fire you're going to put out with thousands and thousands of gallons of water. So that's why I asked that you just keep an open mind on that issue and hear from our fire expert, and we can certainly come back to the sort of question that you have, but it's really not one for Mr. Stiers at this point.
Okay, thank you.
Thank you.
Thank you.
Tell us a little bit about site circulation. Some question was raised by that in the engineer's report about adequate room to stop in front of the entrance gate without having vehicles project onto Main Street, and internal circulation as well for maintenance vehicles.
Again, it's my understanding that the only maintenance vehicles would be pickups coming to the site. The fence is currently set 40 feet back from the curb line, so you can almost put two vehicles back to back or side by side when they come in and still be off of East Main Street to open the gate. As far as circulation, there's a 20-foot wide, 24-foot aisle all the way to the back. This loop drive is 20, but again, it's only for maintenance vehicles. And as far as emergency vehicles, they would come in. We are proposing a hydrant in this location. And once the fire is out, or controlled or whatever it may be, the emergency vehicles can leave through the remaining county parcel.
Where they can back out onto,
Right.
to Main Street, right?
Could that same vehicle that was exiting that way enter that way as well?
Yeah, well, one thing we should make clear, though, about the access onto the other county road is that we have no flooding now, no flooding condition on our own driveway, all the way from Main Street into the site. Correct. So it's really, we may have discussions with county about alternate access, but it's not really needed because you're not in a flood area for our currently proposed driveway, correct? Okay,
And so Glenn, can you clarify?
yes.
Though, as it stands today with your current lease form, do you have legal access through the county lot?
No, right now, we don't, we have just a ground lease for proposed lot 9.02.
Okay.
Okay.
Again, it's just based on discussions with some of the property owners, and the intersection has flooded, but not particularly substantially. I mean, it has not flooded to what this elevation is. So going west, it goes uphill. This is what the DEP requires as far as their regulations are concerned. This would be the limit of it. So you can see from further west, that it continues to go uphill.
Thank you.
I have a question. You said there is no parking if someone comes there to do maintenance for the batteries. Where do they park the car?
They can park, there's no specific parking spaces.
They do have parking on,
They can utilize, this is going to be a stone area,
uh-huh.
so they
Say
can,
this, what are you referring to?
the front portion of the facility.
Right.
So that a lot of that is going to, it's existing stone right now, it's going to remain. So anything inside the fence, they can park their vehicles. What I would expect, since they're working or checking on the equipment, they would drive back onto this driveway,
Oh.
park on the driveway itself, get their whatever from their vehicles, and check the equipment out. So it's similar to parking on your driveway of your house.
Right. So the only anticipated vehicular access to this site is expected to be 2 or 3 maintenance employees once a month,
Correct.
correct? So this is not, we don't have typical parking lots, et cetera, for that, because you have 20-foot driveways, correct?
Yes.
On which, 20-foot wide driveways on which the maintenance vehicles can easily park, do their job, and exit.
That is correct.
Right. You talk about address the height of the proposed fencing, if we can come back to that for a moment.
I believe, yeah, I mean, we can come back to it, but it is anticipated to be 6 foot high.
Right, and the height maximum allowed is 8?
Yes.
Okay. And the gates would remain closed and locked while the facility is not in use?
Closed and locked, and they would have Knox boxes for emergency personnel.
Okay. So a question was also raised regarding how the gates swing. A question was raised by the township engineer in his report. Can you comment on that, please?
It was anticipated that they would all swing in, so they would swing, come into the site, coming through the where the metering equipment is, then it, I guess technically swing out, but it's swinging into the site, and then the same thing in the last gate would be swinging in.
And is that an advantageous condition?
Yes, because if they swung the other way, the vehicle would have to stop shorter and be able to open the gate, so.
Question was raised by the fire official regarding access across Paul Hemus. across the railroad. Can you comment on that for a moment, please?
Again, you have a fee simple property where the rail is, so we couldn't get the access across that property.
It's an active rail line to
And
boot.
it's an active rail, yes.
Right, okay. And I think you'll hear, too, from the fire official that that's downwind from the site, generally?
Yeah, the prevailing winds in the area are from west to east, so that the winds would be coming across the property on the plan from top to bottom or towards Bohemus Lane.
Okay, so it's probably not a preferred location for fire access. Question was also asked about bollards. I gather that none are shown on the plan. Can you comment on that and why they're not needed?
At this point, again, it was expected there would just be maintenance personnel with the pickups. I guess if bollards are really required or requested, we can put them in.
All right, but yeah, I think that the thinking is that this is not a public parking lot where you could have drivers having various issues that could necessitate bollards. Or one reads about those articles all the time. This is a totally controlled site. We'll have a few pickup trucks coming in once a month or so.
Correct.
Okay. In fact, I've been saying once a month, but it's actually every 3 months. I believe that it would be expected to have a maintenance vehicle on this site, so even less traffic over the course of a year. So 2 or 3 vehicles every 3 months. So no bollards are being proposed and certainly no parking lot. In addition, with respect to the fencing, what other security are we proposing on the site?
It's going to be monitored 24/7. So if anything should happen, it is, while it's remote, it is monitored 24/7.
Including security cameras?
Yes.
Right. You mentioned previously that we're reducing lot coverage by approximately 30,000 square feet. Not a small number. Can you go back to Exhibit A3 and show how we're achieving that?
Most of the removal is this dark green area.
Removal of?
The dark green area is currently where the existing stone is. So that existing stone will be removed in these areas, as well as in the front here. That would total the roughly 30,000 square feet.
And in place of that stone which is being removed, we're planting?
Yes.
Okay, so while we're talking about planting, could you comment on the landscape plan?
We have, currently, we are proposing evergreens along the easterly and northeasterly corner of where the best system is. And then also some landscaping in the front of the property. The one thing is we're not we're not proposing street trees because of the fact that the existing lines are on our side. And those are high voltage lines as well. So with the landscapings that we are proposing is lower landscaping, but trying to meet the intent of trying to landscape the frontage.
And will we maintain screening attached to the fence as you have on the site now to provide further screening?
We can, yes. I mean, right now with the fencing that we're proposing, the
Right.
openings are much smaller. Typically they're
Right.
2 by 2. These would probably be closer to 1 or less. But if additional, if fabric or something needs to be part of that fencing, we can do that as well.
Question was asked regarding utilities. It's true that there's no sanitary sewer or gas needed or proposed for the site, correct?
Correct. So it'd basically be communications.
Right.
And then also we're, based on discussions with the fire officials, we're going to extend a line into a hydrant in approximately this location right here, which is just beyond the metering. equipment.
Okay. Will there be a net export of soil from the site?
I don't believe so. We're going to clean up the stone. Again, as I said, that the berm in this area is the topsoil that was stripped. So we can utilize that topsoil to redistribute in the stone areas once it's picked up.
Thank you.
Mr. Stiles, when you remove the stones, then it will become grass area?
Yes.
Completely.
There was comment was made as well about an operation and maintenance manual for the stormwater system. Can you explain why one is not actually needed for this site, even though it often is done for other commercial development?
So with regards to the stormwater, since we're reducing the coverage, we don't need to, and also this is in a metropolitan area
Under the state
under the state
plan.
Right. So between those two, or one or the other, we don't need to provide groundwater recharge. Second component is water quality. Since we're actually reducing the coverage, we don't need to provide water quality. The threshold is a 1/4 acre or more of new impervious above and beyond. So that second component, we don't have to provide water quality.
You say don't provide water quality, I mean water quality treatment.
And then the last component is the quantity. And I have shown through the stormwater report that the existing and proposed, or the proposed meets the existing, both through the flows and meeting the hydrograph.
So that when you say proposed meets existing, proposed what meets what?
Proposed runoff conditions
Right,
meet the existing runoff conditions.
okay, so we're not increasing runoff at all.
Correct. So
Rate or-
because there's no water quality, there's no water, groundwater recharge, and there's no facility for stormwater management, there are no facilities, so there's no need for an operation and maintenance manual because there are no facilities.
Well, Mr. Pantel is composing his question there. My question for you is, so it seems that your testimony is you're doing the minimum because there are things you don't have to do by the DEP regulations, and so you're not doing them. And maybe that's okay. My question to you is, are there things you could do that would improve that site from a stormwater management point of view, which is an area that everybody, especially Bridgewater, is concerned about, even though you don't have to do them? And you don't have to answer that right now if you want to consider it.
Well, I don't think there's really any, I mean, we are improving it just by removal of the 30,000 square feet. So that is a vast improvement. And a lot of times when it comes to stormwater management, they would rather see you do something more non-structural than structural. So rather than putting a detention basin in and that ongoing maintenance forever, do something that is non-structural, that is more natural, so you're returning these areas back to a natural state. So that is actually, I think, more conducive and more in line with the DEP regs than anything else.
Fair enough.
And I think, just the one last thing,
Yeah, please.
it is a low area, so if we were to put a basin in, raised everything up, create more disturbance, so we could drain a basin. So I think what we've done here is the most comprehensive. We don't, it's not that we don't have to do it, we've met the regulations, and I think that's really what they're asking us to do.
Okay.
How about some more trees? Vegetation?
We could do more trees. I think originally what we did was, some of these areas we kind of refrained from because, with the flood hazard area and things like that, again, I hate to say it, but put a tree in it, they consider it volume. So that's why we kind of stayed out of the flood hazard area.
When you say volume, they consider it putting volume,
The trunks would be volume within the flood hazard area.
which is regulated by DEP.
Correct.
Right.
So that's why we technically stayed out of, especially in this lower area. That's why we stayed out of the flood hazard area. We did enough to get the stone out, improve the condition. But as far as putting trees,
Well, can you comment on the vegetation on the lower part of the plan partly around the best facility?
Yeah, we
Talk a little bit about the landscaping plan
I
overall.
mean, this is primarily just the evergreens at this point. I mean, we could supplement this some more.
What sort of evergreen is that?
I believe there were spruces or white pines, but I mean, we could.
Okay,
put it in hand.
so they're trees.
Yeah. And again, the other thing is that the area on mainly on the southerly side of the ditch, there are trees in and around the ditch. So you do have buffering that's in the middle of the site.
Where does the property end and the county property begin?
This is the proposed line, which goes, pretty much bisects most of the stone parking lot area stays with the county. So the line comes and then kind of moves over in the ditch and then squares up around the best facility.
So you can't really speak to what would happen in the rest of that green area because that's not part of your facility, correct? It's still going to belong to the county,
In the back? No.
yeah? Still belongs to the
This
county.
would be the county, correct?
So they could do something else with it and it could affect the runoff, okay?
They could plant trees too.
Yeah, they could.
Can you comment on outside snow removal? Question was raised regarding how snow removal is implemented. Again, your town, Mr. Klein raised that question.
Again, I would expect that would just be pushed to the outside, so when they would come in, they'd push it to the lower areas. When they come into the driveway, same thing, they would just plow it to the outside, make sure it's accessible.
Excuse me, is stone going to be removed from the property? Or just redistributed?
I would say initially redistributed, and then whatever is excess would be removed.
Okay. Question was also raised regarding whether or not an air permit would be needed for the facility. Can you comment on that?
I was told that it does not. There's
Right.
not- it's
There's
not-
no regular air emissions from the site, correct?
Correct.
Okay. Question was also asked regarding a temporary easement given to the town for installation of a sewer line in 1985. Can you comment on that, please?
So there's a easement we have shown on the easterly side of the property that is described as a temporary easement.
Granted to Bridgewater Township.
So this is the sanitary sewer main that was installed in 1985. That temporary easement was granted so that the sewer main could be installed.
Right.
The
So-
reason it was shown is when we initially did the survey, we did an Alta survey that shows all the title information. So that was just, we were requested to leave it on the survey, so
Right. But it's not
So-
real.
technically it doesn't exist anymore.
Right.
It doesn't exist anymore, okay. Continue.
Sewer line was installed.
And it was extinguished once it was done.
Right. Yeah, by the terms of the easement, that's what happened.
I'm trying to manage our time here, so when you're done with Mr. Pantel, when you're done with Mr. Stiers, we still have to have him hear questions from our board professionals.
Of course.
And the public as well. And before that, we're going to take a break, so.
Yep, no problem, no problem. There was a question raised regarding possible adjustment of the route of the fire service line.
Right now, we have it shown along the side of the driveway into the hydrant in this location, which is just past the metering equipment. I think Jason said it might be too close to the poles, so we can adjust it over. That's not a big deal. It's a water line, so it really can go anywhere.
Great. And all the electrical equipment, of course, is outside the flood hazard area,
Yes.
correct? Okay, I don't have anything further at this point for Mr. Stiers. Undoubtedly, we may have some additional points in the course of the hearing for him, but I'd be glad to turn over to questions for the board.
Right. Before we do that, we are going to take a 10-minute recess, and then when we come back, and for members of the public, we're going to see if there are any additional board questions, and we're going to ask our professionals to question Mr. Stiers on his testimony, and then at that point, you will have the opportunity to question Mr. Stiers about any of the things that he testified to. So just so I'm managing your expectations as well. So with that, let's take a 10-minute recess. Roll call, see if we have everybody accounted for. Nobody's rowing out in the parking lot. Is your mic dead? Yeah, it sounds like something.
Okay.
Chairman Kulak.
Here.
Here.
Mrs. Amin.
Yeah,
Mr. Franco.
Here.
Mr. Fresco.
Here.
Ms. Rose. Ms. Wiseman.
Here.
Mr. Vesio.
Here.
Mr. Colucci.
Here.
Mr. Mignella.
Here.
And our board professionals are also here.
Mr. Older is here, thank God, so we have them all. Thank you. Okay, Mr. Pantel, before we continue, and for the public as well, we're going to continue with, open the floor to questions from our professionals first about Mr. Steyer's testimony, and then we'll open it to the public for questions about Mr. Steyer's testimony. So, Mr. Klein, would you like to start?
Let me get the microphone near me because I know that's critical. Good evening, Mr. Steyers. You were talking about impervious reductions, and I hinted about this in the break. According to, you said roughly 30,000 square feet. I do believe it's a little less than that. It's still a significant number. Using the numbers on the cover sheet of your plans, it comes out to roughly 22,000 square feet reduction. And I also note that a big chunk of the turning stone into grass is actually on the county property, which they also will need permission for, because right now that's off-site work.
I'm sorry, when you say they will need permission, who is going to obtain permission for what?
The applicant will need, just how they said they would need an easement to go across the county parking area. If you look, the dark green segment south of the Bess on that plan right there, that's county property even after the subdivision. So that's where a significant portion of the reduction in impervious is coming from. And since that's going to be effectively off-site, they'll need permission for it.
Understood.
There's a discussion. I am glad to find that that berm that's there is the topsoil that was stripped off the property, because a lot of times something like that is spoil from the roads and will end up having contamination in it. Being topsoil is a much better.
Right. That's one of the reasons I was asking the question with respect to the material, the stone material which exists, whether that would have to be tested before it's trucked off-site or...
Yeah, and actually, thank you for segueing that way, because there's not going to be a cut or fill, but a good portion of stone is being removed and taken out. That's a cut. It is good that the berm will be redistributed and that topsoil will be spread, but it does sound like that there is a cut going to take that layer of stone out of that area. Would you agree with that, Mr. Steyers?
Yes, to an extent, maybe a few inches, 6 inches or so.
So, and clearly, the typical procedure for that, if you're exporting material from a site, would be to have it assessed for any contamination. Is that correct?
I think that's typically a
Standard procedure.
Yes.
Right.
And especially if you need to actually take it somewhere, they're going to need lab testing to be willing to accept it.
Yeah, exactly. The exporting company.
The material which is being taken off-site will be tested. What about the material which remains on-site?
Mr. Steyers has offered testimony in that respect. The board can accept that or can require testing if they want further support.
So it would be required to be tested?
The board's within their rights to require it.
Yes.
In my opinion.
Okay, thank you.
Talking about snow removal, just because that was one of the most recent
Yes.
things. I think there's a problem pushing snow, which may have road salt and such in it, into a wetland. And you also want to avoid pushing it against the perimeter fence of the Bess, wherever necessary. But there is some clearance, at least on the west and south side of that loop. And then to go in another direction, Mr. Stiers, and this may not be you, is there a circumstance that you can see where a fire truck accessing the site would have to actually go around that loop within the fence around the BES?
No, but, and further testimony we'll give by Leonard.
Okay, that's the bulk of my comments, unless the board wants to talk about lighting, because that was a,
Lighting is an open question, and maybe Ms. Sarmad will have some thoughts about lighting as well, but Mr. Stiers, if I understood you, the facility itself doesn't require any lighting per se, and in the event it's serviced, then there would be lights that could be used if the conditions are such that would require lights, and those lights could either be controlled remotely or manually. So right now, we have an open question about lighting, and part of it has to do with the unique nature of the site, and the other part has to be with what we might, as a board, and what our professionals might be comfortable with. So I'm not certain how to resolve it right now, but I think we can leave it open so that the professionals could confer once we have additional information, and then come up with a lighting plan that's mutually acceptable to both parties and the board as well.
before I hand off.
Yes, please.
My thought was that having lighting on that site might actually add to the security of it, if you don't want to totally darken site. Just throwing that out.
No, I appreciate the thought, and I think it's an open issue because we'll be discussing a variety of things moving forward in terms of security of the site and so on. That's a relevant point, but let's hold that until we understand more. Because you could also argue that if you light it up, then everybody knows where it is and becomes a target. So I'm not certain how to go. Mr. Klein, do you have an opinion?
I have a few, this is perfect to actually give some thoughts to the board for them
Please.
to digest. The light at the driveway, whether it's moved slightly or not, that's a minor spillage. Lighting for work purposes, they can do it by a switch, or it's very common with unattended equipment, industrial sites like this. You'll have a twist light that you turn, it's a timer, you turn it on so you work, so you don't have a circumstance where the worker left
Right.
and the lights were left on. The other one the board may want to consider is motion-activated security lighting.
Mm-hmm.
Because, agreed, you don't want to draw attention to it, but if someone walks on or,
Right.
bolt cutter to the gate or something, motion detector pulls on for that and kind of, it has a deterrent effect. The board may wish to look at something like that.
And we also have residential buildings that are very close to this facility, so we want to make sure that any lighting that's proposed doesn't interfere with their quality of life as well.
Right.
So we really have to strike a balance here on, and we would need something to respond to, something definitive to respond to, once we've had an opportunity for the professionals to discuss it further, perhaps.
Yeah, and a lot of times you end up not putting motion detector or security lights on a unmanned installation because you'll have animals that will trigger it. But the way this is set up, you probably aren't going to have too much of that. But those are the things that the board can balance, and I wanted to just put that out there.
Thank you. Ms. Armad, did you have questions for Mr. Stiers?
Yes, Mr. Chairman, thank you. And just one thing I wanted to address that wasn't necessarily Mr. Stiers' testimony, if I could, but something Mr. Pantel had mentioned.
Yes.
He had included an aside about the bulk variances being subsumed under the D variance.
Right.
I don't think he necessarily gave any citation on the case law that would support that. But nevertheless, there isn't that much case law, so I can pinpoint that the most recent one, about 20 years ago, the Paleo case, included the language, I think, that is relied upon, and we've seen in certain circumstances. And it notes in that case that generally that a C variance and D variance application, don't exist together and that they can be subsumed. And it cites an example of a gas station in a residential zone, noting that, the gas station use couldn't be put under residential standards because the residential zone doesn't contemplate a service station. So how
Yes.
could it comply with those bulk standards? And I think in in this case for two reasons. One being that most of the bulk variances that I included in my review and that have been cited on their plans are all self-created through the subdivision, not the use variance. Most of the bulk variances are related to the lot configuration, which is a direct correlation to the way it is subdivided from the current lot as it exists. So I just wanted to make that clear, that my opinion, and I know it differs from Mr. Oler, and I talked to him at the break to let him know, is that my opinion is that those bulk variances are related to the or some of them are related to the subdivision, which would be separate from the use variance
Yes.
contemplation, right? And then the other kind of piece of that is that this is not a non-industrial use in an industrial zone. It is an industrial use. I think we've heard from the applicant themselves that they believe the only difference between this being permitted and not permitted is that it's not a public utility, it's a private utility.
Yes.
So the zone has contemplated a use of this nature, right? Industrial or a utility use of some sort, right? Or a infrastructure use. And so I would say, in my opinion, the bulk variances are separate from the use variance. They're not subsumed. This is an industrial zone, and this is a particularly industrial use. So I just wanted to set that up for the board as my opinion in relation to what Mr. Pan.
No, I appreciate you doing that, and I thank you for that. When I look at the site and how it was subdivided, and there are, I'm certain that the two parties, the county and the applicant, have come together in a way that created that subdivision based on their requirements for the site. And as such, they've created their own limitations, or the county, and they agreed upon certain limitations that in many ways, in my opinion, benefit them because it relieves them of some obligations that they might ordinarily have. But I appreciate your view. Mr. Oler, did you want to comment on that as well?
No, I think Catherine raises a good point that the use arguably is permitted if it's a public utility, which the applicant has argued in its brief filings. And, under Pulio, truly, if it's, a non-permitted, a truly non-permitted use versus a permitted use in a zone. So I think those are some good points to that.
But, yeah, I'd like to make one point, though, in response to that, is that the ordinance does recognize essential services as a conditional use, I believe, in all zones in the township. We've acknowledged this is not an essential service as defined in the ordinance because the operator will not be a government or public utility at this juncture. However, the physical use will be the same as you've heard in prior testimony to essential service use. And the conditional use section of the ordinance 126-350, which allows essential services in all zones, specifically does state that there's no specific regulations governing it, i.e. bulk standards. So the township ordinance, I think, acknowledges that you do need this vast degree of flexibility when it doesn't prescribe bulk standards for essential service as in all zones in the township. So I don't think it's fair to say that because this is an industrial use in an industrial zone, that are necessarily subject to all of those setback requirements and the like, because the ordinance does recognize that essential services would not be subject, if they're allowed as a conditional use, would not be subject to those sorts of requirements. That's section 126-350.
And just so the board knows, the M2 zone principally permits essential services, so I think that's a moot point. It's principally permitted in the zone. It's contemplated by the zone.
And understood, but throughout the township, but again, throughout the township where they are allowed, the township has allowed this degree of flexibility. I think that's germane as well. I understand that it's permitted in this zone, but again, for essential services, where they are allowed throughout the town has imported an unusual degree of flexibility. I don't think that's irrelevant.
Understood. Thank you.
Thank you.
Mr. Stiers, more direct questions for your testimony. In your capacity as a site engineer, did you have any any input on the siting of these structures and where they'd be located? Was that driven entirely by the client, or was it was some of your engineering expertise involved in that?
By the client.
By the client, thank you. And additionally, in the proposed subdivision, were you involved at all in the the lot line changes to the subdivision, or you brought in after that was done?
It was pretty much set. I mean, I think maybe fine-tune the angle point over the stream, but for the most part, it was laid out already as well.
Okay, and is there, or are you aware of, or were you involved in any conversations about potentially utilizing the entirety of the property?
No.
No, okay, thank you. I know Mr. Klein had discussed a little bit about the coverage and the kind of particulars of the coverage reduction. Can you, I know 22,000 square feet approximately in sum between the two lots is being reclaimed from improved lot coverage to pervious coverage. Do you know what amount of that is on this particular portion of the lot? So which, I know he noted that part of it is on the other remaining county lot.
No, I don't know specifically what's in the back. As far
Well,
as
I meant like what's on this portion of the proposed lot where the best station is proposed, how much coverage is actually being reduced on the lot?
I don't know specifically what this number is, so I can get that number.
I think it would be helpful, right? I think it would be helpful.
I also think that, to interrupt you for a moment, that it's very helpful for both you and Mr. Klein to point out that when you were talking about removing some of the stone material and replanting grass and so on, I don't think the board received a clear picture that you were talking about the property that is still owned and controlled by the county. So in the future, if you're covering that, it would be helpful to us if you were more clear as to where the reduction in impervious coverage were to take place. And that's just my observation, so.
I did outline this is where the existing stone is. That was
Right. And what I'm saying is that it gets blurred between that which is controlled by the applicant and that land which is controlled by the county. So even though your calculations are impressive, it's misleading to us to think that, oh, well, that's on the best site, not on the county site. I'm not saying you intentionally did it.
project subdivision, but
Correct.
announced on these properties, plural.
And the applicant is requesting certain variances for their portion of the property, which is to be leased. So we want to be clear that we understand, even though, as you're saying, you're looking at the entire site to be approved as part of the subdivision, it would be helpful to us if we could be clear as to which part of the property was being improved. By,
That number for you for the next meeting. If
great, thank you.
Also, if I could, unless, I don't want to interrupt your planner. You have more questions?
I do have more questions.
Yeah, sure. 'Cause I'd like to come back on a point of clarification or two, but go ahead.
Okay, and maybe this has to do with your question, but it just came up from Mr. Steyer's testimony. Mr. Steyer's, on the cover sheet of the plans, it says the applicant owner is Rockland APV. Is the county also a co-applicant to this application?
They have consented to, they've consented to the application.
Well, they've consented if there, are there improvements or changes proposed to their site that would require them to be a co-applicant? Or
Not
on the
require
site
them to be
plan?
co-applicant, but they have consented to the entire application.
Okay, thank you. Mr. Steyer's, on the colorized plan, it shows where the best units are in the back there. It shows green underneath them, essentially. Is that going to be a grass area? Because on the site plan, it shows something a little bit different than there's a lot of line work on the plans. On sheet 4 of 10, it's showing a hatched area, approximately under half of them, showing edge of stone. It's like. Oh, it's. Yeah. Oh, that's the dent. Yeah.
That is the, inside where the best system is, that's showing where the stone is to be removed.
It says install 6-inch TH dense graded aggregate. What does that mean?
Inside the loop?
Inside the loop.
That would be stone inside the loop drive.
So is that area considered improved lot coverage that should be included in the calculation? And has it been, or will
I
it
would
be?
say no, that should not be, because it's not something that's going to be driven over, so it'd be almost more like decorative stone. So
I
that,
believe our ordinance would require anything that's not basically natural to be considered coverage.
I can look into that, but I don't know if, it's always been my understanding, if it's decorative stone, for example, say if it was in a garden area, that would not be counted as improved coverage.
Under whose rule? Is that a DEP rule?
No, that would be the township. But we can look into that and clarify it.
I think that would be helpful. And if there are any other areas like that that are proposed to be reclaimed from the existing stone, but with new stone on top, whether it's decorative or whatever, I think that would be really important. I think right now that the colorized exhibit is not exactly,
But we can get that number along with the number that the chairman is looking for.
yes, I think that'd be helpful. On that same sheet, or I guess generally, because I'm not following, there is a fence proposed, and on sheet 4 it shows proposed 6-inch chain link fence around the middle of the site there, and it seems to end
In the middle of the site,
in the middle of the site.
that goes down the property line?
It goes
the
down the
proposed?
shared property line with, the proposed property line.
Right, and then it just past the metering equipment, it stops, right?
Yes.
Right, that's the intent between the two properties.
Is there an openness between the two properties, that there is access
At
between
this
the two?
point, yes.
So there's no fence, there's a fence only around the best, only around the metering facility, and then it's completely open to the county portion of the property, correct?
Yes.
Okay. Is there any reason why the site's not proposed to be fenced?
We contemplated closing it off, but with the ditch in between, we didn't want to put a fence across the ditch.
Because you're not allowed, or because you didn't want to try to seek those permits?
I don't think it would be practical to put a fence across a drainage ditch.
Okay.
If we could elevate it so that the flow goes underneath, it's a possibility, but the reason that we did not put the fence there is that reason. And that they're self-enclosed on either side of the ditch.
It looks like there's some access, there's existing stone, it looks like there's some access. And I'm just bringing this up because the chairman has raised questions about security and the security of the site. And I think right now, this potentially is another access point, because the county site isn't, overly secure, I'd say. And so it does provide another point of access. So if security is a concern, this would certainly be one weakness of, any kind of security plan. A few things about the EIS that was provided. Page 2 does note that this is a permitted use in the zone, so I would just request that that be modified, because clearly it's before the zoning board for a use variance. Additionally, page 11 includes a section on the wetlands and notes that a stream exists on the site as well that flows from west to east and collects all the storm runoff from the existing site. Is that the one and the same with the ditch?
Yes, and that would need to be updated, because this was prepared before we received the LOI.
Okay, and it also notes this stream will be utilized for the proposed discharge. Is that still what your testimony was previously? That it will be
Yes.
utilized for discharge?
Yes.
Where does the ditch flow to?
It flows to the intersection of East Main and and Polhemus Lane. So there's a 21-inch pipe at that intersection is where it goes from surface flow to pipe flow.
So it will go directly from the surface flow to a pipe, not to another body of water or directly to another stream, not to the Cuckles Brook, none of that.
Cuckles Brook actually goes behind that former restaurant or
Yes,
whatever you
it
want
does.
to call it. It actually goes behind there.
And then across the portion of the PSC&G.
Yeah, exactly.
So there's no chance that if there is any kind of contamination or runoff or, battery leakage from the site, that it's going to go directly to another body of water?
Not overland, no.
Not overland, okay.
Correct.
And if it is flowing, if there is any kind of contamination that flows off of the use for whatever reason, if there is a leak or a fail, what is the consequence if it goes into a stormwater drain, into a pipe? Is there any chance that goes into, has any consequence?
It would flow to the Cuckles Brook if there was something in that waterway.
It eventually would go to the Cuckles Brook?
Yes.
Okay. And if there was, let's say there wasn't anything catastrophic that happened, there was nothing that was detected, is there anything that would, raise a question about water contamination? Is there anything that would, how it would be detected if it was happening slowly over time?
I can't answer that.
Okay. I think that's all I have for Mr. Stiers. Thank you, Mr. Chairman.
Thank you very much, Ms. Arman. What I'd like to do now is open the floor to the public to pose any questions to Mr. Stiers about his testimony. So I know there are a couple members of the public here. If you'd like to step up, introduce yourself, and just make a comment or ask any questions about his testimony. You're not obligated to, just so you know. Would you come up to the podium, please? We're all friends here. You don't have to be apprehensive. And please tell us your name and address.
Jim Gamaco, 744 East Main Street, Bridgewater.
Can you spell your last name, please?
Gamatko.
Thank you.
Okay. James.
And your address was?
744 East Main Street.
And how close are you to the subject property?
I'm next door neighbor.
Next door neighbor.
Yeah. Right next to me is Somerset County.
Right.
And then this property they're talking about on the end, down by Polhemus Lane and East Main Street.
Right.
Okay.
Very well.
Yeah.
So your questions for Mr. Stiers or comments on his testimony?
Excuse me, I think this is only questions at this point, right?
It's only questions of his testimony.
One question, that's all?
Yes.
Yeah, my main question was about the water, that intersection floods out, like today is raining real hard.
Yes.
If you go there with your car, I don't think you're going to be able to get through.
Okay, excuse me, now we're getting into comments
I
from...
think he's leading into his question.
Well, you said I could ask a question.
Yes.
So if they're aware of it, apparently they are.
Well, I think it's a good question. I think that the way in which you posed it, you offered a little additional information, but your question was was about the intersection and its flooding, correct?
Yes.
Okay. And Mr. Stiers, you acknowledge that intersection floods. The question for all of us, though, is here's a resident who lives there. How far does it flood? Does it cover all the way to the former Club 21? Does it go across Main Street? Does it go in the easterly direction? And does it continue on Polhemus does that roadway flood? That's, I think, where we're going.
Yeah, well, if you're coming from Boundbrook, you come downhill to the intersection of Polhemus and Main Street, the water gets maybe about a foot deep, sometimes a little deeper. And it'll stay there for maybe 2-3 hours. Then if it stopped raining, it'll settle down and the water goes into, I guess, that drainage pond.
You want to ask him if he's aware of that condition.
Are you aware of that, Commissioner, sir?
Yes, I believe that's consistent to the questions I've asked for, like, for example, the person I work for that owns Club 21, he did say the intersection floods, but he said that the buildings did not get water in them. So,
Well, I didn't say the buildings.
what he was saying is that 1 foot deep, it makes sense.
Okay,
Yeah, because it's like a hole right there, Main Street.
okay. Did you have additional questions for Mr. Stiers?
No, I'm good now.
Okay, thank you very much. Mr. Stiers, on the basis of that question, though, I understand what you're saying, that it's consistent with what you anecdotally interviewed people in the area and got some indication as to what that is. My question is, does it continue on Polhemus in a way that would impact your site?
No, because Polhemus goes up gradient as well.
Mhm.
But I mean, either way, we're talking real-life conditions.
Yeah.
versus The DEP regulations
Yes.
anyway. So we have mapped what the DEP requires.
Right.
So as you can see, if you continue up Polhemus, this is the limit of the line right here. It continues to go uphill. Eventually, you get to the top of the hill, and then you come down the hill towards the sewage authority.
Yes,
If you make a left, you go down towards the water.
water treatment, yeah. Okay,
Here, it continues to grade until you cross the railroad tracks.
And I appreciate that. It does appear, though, to my eye, and we'll get some additional insight perhaps as we continue, that you're like really threading the needle there. There's not a lot of margin for error. Is that true?
I think if you look at a plan view, it seems like there's not much margin, but you also have to realize that the grade slopes up.
Right.
There's essentially like a hill right here.
Mhm.
So where the best system is.
Yes. Okay. No, I appreciate it.
It does look expansive on a plan view, but when you throw the elevation in,
Right.
take that into account too.
Thank you. Board professionals, additional questions? We're good? Public is good?
May I ask a question?
So we can conclude,
May I ask
oh,
a
I'm sorry.
question, Mr. Chairman?
Go ahead.
Do we know if the runoff from these two lots contribute to the flooding at the intersection of Main Street and Polhemus, or does it go into that 21-inch pipe before that?
I think anything that drains to that area technically would contribute to the flooding, but you have to keep in mind that Cookles Brook comes all the way from Route 22.
Yeah, we can,
Goes all the way through the apartments, you know, all the way up to Route 22. So relatively speaking, this has very, very little to do with it compared to the Cookles Brook.
And is what we're doing on this site, does that in any way increase contribution to flooding?
No, we're actually, again, you know, I made the mistake of the 30,000 is 22,000 square feet, but we're still reducing the coverage, which is improving the condition.
please.
Forgive me if this is part of your fire person versus testimony, but where on that site, if you had to have a fire truck or two on the site, where would they go? How would they fight what might be a fire? Number one. And then Craig, number two, if they're fighting it with foam, your question, where is the foam going?
Yeah, I think the questions about foam, that first of all, that presupposes there's use of foam. We really have to defer that to our fire expert.
Assumption.
Yeah, but I wouldn't assume, I really don't think it's right to assume that, okay?
Do you think,
The fire truck, to get access to the hydrant, you can point that out, Craig.
So, and Leonard will give you the testimony substantiating it, but the process or the thought process on our side is that to stay 200 feet from the facility. So that line is approximate from the best facility is approximately in this location, which is just before the metering. We have put a hydrant at that 200-foot point. So a fire truck would then stay off of East Main Street, stage next to that proposed hydrant, and if any water
Is you,
Make sure somebody talks about turnarounds.
Mr. Chairman, I think it might be prudent to potentially have the civil engineer
no,
come back after we hear the fire testimony, because there might be new information that is provided to us.
I think that's reasonable. Mr. Pantel, do agree that once we heard your fire expert's testimony, that if Mr. Stiers is required to provide additional insight as to the site engineering to accommodate some of his things, that we can have him come back.
Of course.
Okay, very well. Then with that, are we done with Mr. Stiers this evening, or do you have something else?
Sorry, I just have,
Oh, Ms. Sarmat has a couple of questions.
Mr. Klein might too, so not to
Okay.
put myself under the bus. Just to make the, I think Mr. Stiers has provided a little bit of anecdotal knowledge, right, about, particularly about the flooding. So I just want to make it more complete so I can understand it better. Mr. Stiers, you referenced the former restaurant, kind of kitty corner to this property a few times, which is your client. How long has your client owned that property?
I believe it was 4 to 5 years.
Okay, and are those buildings currently inhabited?
To my knowledge, no.
Okay, thank you. One other question, I apologize for not bringing this up earlier. The fencing that is proposed is internal to the site. There is an existing fence around the perimeter of the county facility. Is that perimeter fence proposed to remain in place?
I think during the process and the discussions going forward is that that fence would come down and we would put up the new fence that would, again, mimic the PSE&G fencing.
Okay, because right now I think they have a fence with some sort of like screen inlay, right? It's got a green.
It's almost like a panel system.
Yes, it has like some sort of paneling. It's not interwoven or anything, but
Correct, yeah.
I just wanted to make sure that that's understood as well, because right now it goes around the entire perimeter, and that would be, changed.
And we would love the opportunity to revisit that fencing, simply because what exists today is an eyesore at best, maybe dangerous, I'm not even sure, but that's something we would like to revisit. Mr. Klein, did you have something you wanted to add?
And I just have one more.
No, go ahead.
In line with that, it's my last one, I promise. I think the landscaping plan was brought up earlier. I think Mr. Stiers has answered that some of the constraints on the property make it difficult because of wetlands and whatnot to do plantings. But I would say that right now, the current landscaping plan leaves a lot to be desired,
Okay.
considering, and I think I raised it in my review, I think any kind of embellishment to the landscape plan that helps visually screen the site and provide, an improvement to the conditions there are today would be welcome.
I think it's fair, Mr. Pantel, to ask if your client would agree to any additional improvements to the landscaping plan as a conditional of approval if it should come to that.
Yeah, I was taking careful notes in response to that last comment from your planner, so yes, obviously we'll take that under advisement for sure.
Thank you. I'm sorry, so Mr. Klein, did you have a question?
Yes, and I feel better than Ms. Sarmed also had a recross, so I feel better.
That's all right, go right ahead.
We had talked about stormwater and major development, quality recharge. Didn't have any problem with his stance on those, but also with major development, there's also a requirement for green infrastructure. I did speak briefly with Mr. Stiers about that during the break, that will be required. I just basically wanted to put it formally on. It's in the report.
Yes.
And there was also, we had a brief discussion. When I did a site visit, I found a flag and what looked like utility mark out in the stone area. I took pictures of it, and it's in my report. I was clarifying that with Mr. Stiers, that they need to, I don't believe that they've investigated that thus far, but they should, and I assume they will.
Yeah, I misunderstood his statement. I thought it was a mark out for where the system is going to be,
Yes.
and it's Trinity, right?
Yeah, it's
So it was a
Trinity.
misunderstanding, so we're gonna
Trinity Subsurface LLC is the name on the flag that had a paint stripe under the flag that's in the stone right now, or well,
So they're
several
more
months ago.
Utility we have to look at, so.
But between the two of you, you should be able to resolve that and report to the board as to what's there and what needs to be done.
Correct. And
He's make the, yes.
Okay, fair enough.
I think I'm done, sir.
Thank you.
One follow-up
Please.
question. Ms. Sarmad did ask Mr. Stiers about whether or not he had input into the siting of the best facility and the overall subdivision configuration. And generally, he did not, other than some refinements to the subdivision line. But notwithstanding that, my question for you is, does the layout that was proposed and is now on your plans a viable layout for this use on this site?
I believe so, yeah. I mean, it's a low volume, I guess you could say, usage, so doesn't need much area to work properly.
And your engineering that you've implemented for the project is consistent with sound engineering practice to accommodate this proposed use on the site from a civil engineering perspective, correct?
Yes.
Great, thank you.
I'm sorry, we were just having a sidebar conversation, but I appreciate your statement as well. And the objective, obviously, that we have in mind is to create a degree of safety in this project, and we're trying to learn as much as we can, both from an engineering perspective. We've heard how the facilities will operate from the representative Trina Solar. Do you want to transition into your fire safety testimony?
Yes, we can do that.
Let's do that.
What is your policy and practice on overall timing for this evening?
The microphone is eluding me there, so if you can get a little closer to it.
Yeah. What's your practice or policy on timing for this?
Well, we're not going to be able to get through a lot, but we can, Mr. Weidling?
10 o'clock.
10 o'clock, that's our goal.
That's your goal. Understood. Okay, no problem.
And we don't want to cut him off mid-sentence, but
Of course. Okay, so I'd like to have
Sir, would you stand and raise your right hand, please? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth? I do solemnly swear. And your full name, please?
My name is Leonard Ganesh Dionorine.
Thank you.
Certainly. D-E-O-N-A-R-I-N-E.
Thank you. So could you please describe for the board the nature of your qualifications and experience and your involvement in this project, and with reference to your resume, if you would, please. And we'd like to mark Mr. Dionorine's resume as Exhibit A6 with today's date, and then after his testimony, I'll provide that to you.
Is his resume in the response plan? I don't think so, right?
No.
Okay. Okay.
Well, good evening. My summary of my qualifications I can give you very quickly, then I'll go into greater detail. I'm a firefighter. Been a firefighter, took my first oath of office in 1974. I've been a fireman in large departments and small departments. Small departments being 8 active people, large departments being career outside of Washington, D.C. with 1,500 men and women as firefighters. I've been in the fire responsibility as a volunteer, career person, sometimes both at the same time. Many years, firefighter, EMT, officer over the station, all the way up to deputy chief over training and operations and career department. So a lot of experience in going to fires. Specialized in industrial firefighting for about 10 years, doing refineries and terminals and ports and rail cars and pipelines. And now even do some of that internationally, which I'll cover in a minute. But a lot of experience in active firefighting. My background currently, I work full-time for an organization known as Jensen Hughes. It's a private corporation. And basically, it's the world's largest fire protection engineering firm. The closest thing to it is about 1/7 our size. We have 1,800 scientists and professional engineers, basically serving in 100 offices around the world. Within that organization, I'm a senior director of emergency management, and my office is in Chicago, but I live in Fort Worth, Texas, and basically work out of my home and travel. From a training standpoint, numerous years of training and providing training to firefighters to prepare them for what they do. Firefighting is my calling, not my occupation, not my avocation. It's truly what I live and breathe every day. Very concerned about the protection of firefighters. From an educational standpoint, I have an associate's degree in fire protection. I have a bachelor's in fire protection from the University of Maryland. I have a master's in emergency and disaster management from the American Military University. I served for about 6.5 years in Texas in the Texas State Guard, responding to disasters at the direction of Governor Perry, now Governor Abbott for a while, and also serve as an advisor to the state of Texas on disaster management. I do carry a certification as a certified emergency manager. It's an international certification. I do work internationally. That's my CEM certification. I also am a certified there's an organization called the Board of Professional Certified Engineers. They certify me in instruction and in health and safety. And when I was in the military, I achieved the master level in emergency management while in the military. Served as an NCO staff sergeant. One of the things I also want to point out, for about 11 years, I was a director of emergency management for a healthcare corporation in which about 9 different states, 72 hospitals, 300 other buildings, I supervised disaster management on a large scale for them. Because I think one of the things that'll come up tonight potentially is about protecting a hospital and its air intakes and such. So a tremendous amount of fire department experience. And what I bring to you today in training and education and experience is a passion for emergency response. And my involvement here initially with this organization was to come in and prepare a plan for emergency responders going to this specific site. And that phrase, this specific site, is what's unique. I've done emergency plans for a number of data centers and for other battery energy storage systems throughout the country. I have a Fortune 100 companies to retain me to do plans they'll use for 72 different sites. So a lot of impact in this area, a lot of interest across the country in doing this well. And of course, from my perspective, doing it so the operators and emergency responders are protected. With that, I'll ask, are those qualifications adequate? Did I miss anything?
I think that's good. So we would ask that Mr. Dianarine's qualifications be accepted and that his testimony be admitted as expert testimony in the field of fire safety, firefighting, including, of course, specifically industrial situations encompassing the proposed BEST facility that's before you this evening.
Well, first, let me thank you for your service as a firefighter and someone who has a passion for it and for keeping people safe. And to answer your question, yes, we accept his qualifications as an expert in this field.
Thank you. I'll provide his resume to Ms. Probst. So could you please proceed to describe for the board an overview of the proposed facilities and your conclusions as you go through the process? I know we'll want to touch on your emergency management plan, but before you get to that, could you give an overview to the board?
Well, certainly. So this particular site and its emergency planning process is designed to meet certain specific regulations. In New Jersey, we have New Jersey's edition of the International Fire Code and the New Jersey version of the International Building Code. In addition, the National Fire Protection Association, NFPA, has published standards. They're non-required standards that have to be adopted by local companies, local organizations such as yourself, as communities have to adopt it. But they wrote a standard called NFPA 855, which addresses all the features for such battery energy storage sites and how it should be done safely. So as we looked at what to do here to make sure it's done right and done safely, we took in those building codes, fire codes, and even consensus standard codes. And as we looked at the equipment specifically that was given in testimony for Joe Brown, he took his equipment and subjected it to Underwriter Laboratories, UL standards, I believe it's 9540, and received a certification of the equipment under 9540A. The equipment is certified. So it's gone through a safety standard and safety testing. I'll talk about that a little bit It's not the strength of my expertise as how these things were tested, but they were torture-tested equipment. So once again, specifically to this site, which will be different if I go next week to testify before another board, I'll speak just about that equipment, its testing, and its performance under stress. What would you like?
While you're on that reference point to the specific site and the specific equipment and the testing, you mentioned that it was tested and received a rating of some kind. I think you mentioned a UL rating. The testing was done here in the United States or in China. I'm not sure where it was done, and which agency then would issue such a rating or standard for it to adhere to.
I'm not able to give you sworn testimony regarding where they conducted the tests. I know it meets that standard and was certified under UL, Underwriters Laboratories.
And is the UL then a certifying agency that's a domestic agency here in the U.S.?
That's my understanding. I can look over my shoulder and look for a nod from someone in the audience if that will be acceptable.
You can do that, sure.
Yes,
And the value of that UL rating on which we might be relying, how would you describe that in layman's terms?
a little bit beyond my scope of practice, but almost everything in my house, my toaster, my coffee maker, everything I have is UL labeled on the cord itself. I mean, it's going through testing standards for that particular piece of equipment, the microwave, et cetera. And here what we're seeing is on an incredibly expensive testing system, this equipment has been tested and meets the UL standard. That's about all I can say. I can't
That's right.
more than that. It's been around for decades as far
Right.
as setting the standard.
There are standards, obviously those standards differ from your toaster to your coffee maker to something as advanced as a battery energy storage system using brand new technology. So we still have yet to really grasp the magnitude of that rating, other than that they observed or evaluated the results of the testing and it met their standards.
Yeah, so we do have copies of the applicable UL certifications that have been obtained, and we can provide those.
And I'm looking for something a little more from your
Of
expert.
course. Yes,
About
we
the
had
value
Trina
of those
Solar,
things.
we had Trina Solar compile those for us, and we can provide them to you.
Okay,
Okay, so
Thank you.
it's, yes, and it is more than just your toaster.
exactly. So please continue.
So one of the standards we used here was the NFPA 855 standard for such, specifically written for this type of installation where we're going to get the energy pulled back out to reduce energy costs and give it reliability even during storm situations where that battery will continue to power up things when the substation goes offline because of a storm. So we've seen that, and 855 is one of those key standards from the National Fire Protection Association. For me personally, I looked at the NFPA as being one of those knowledge sources, which is a compliance consensus standard. It gets voted on, it gets reviewed. I like it very much. So in the writing of the emergency plan to protect the firefighters, protect the public, I looked to 855 to gain ideas and standards and recommendations. And then you'll see as I go forward that we went beyond that. And we took and installed greater distances for protection, greater advice for the firefighters. And I'm going to have a chance to talk to you about the suppression tactics for such a fire. We'll get there. Features about this particular site I know is still in discussion as far as fences and gates. I will tell you, for access to the facility, there's going to be gates. The gates will be locked. What we typically use in the fire service is a type of vault to put in keys. We call it maybe a company called Knox, just like Fort Knox would be. And inside we put the keys, so in case there's an emergency like a medical crisis inside the fenced-in area, when the fire department or ambulance responds, they can unlock that vault, get out the keys, and gain access. So it'll be gated.
Is that what's commonly referred to as a Knox box?
Yes, and that's a trade name. There are many different vault types. In this one and this plan, we put in the Knox box, and that's what they'll be providing. And those gates are nice and wide for ambulance traffic to get in. As far as suppression, this is where it gets interesting. Everyone's worried about a fire involving lithium-ion batteries, and they should be worried. I'm not worried about the devices I put in my ears. It has lithium-ion batteries in that. It's the AirPods. I'm not worried about my cell phone. There's lithium-ion batteries in there. I'm not worried about my drill at home. Has lithium-ion batteries in it. My lawnmower is a lithium-ion battery-powered lawnmower, but I'm not worried about that because the incidence is low and the consequences, I need to be concerned and protect myself. Don't sleep with the lithium-ion battery underneath my pillow where my phone is. I take precautions. This situation with these batteries is rather unique when it comes to suppression because it's monitored. The battery is being monitored remotely. They know, is it performing, not performing? Is it charging, is it discharging? What's the percentage of charge on the battery right now? And they're tracking what's going on. Is it hot inside the containment? The vessel that it's contained, it looks like the back of a tractor trailer to me. Is it getting hot in there? They have an air conditioner they put in. They're using a glycol water mixture. It's like I used to put in my radiator of my car as a medium for absorbing the heat. So as far as suppression, the opportunity for a fire is low, but it has to be respected. I will tell you that they took at least one of these tiny batteries that makes up the module, makes up the set, and they exposed it to temperatures that were extreme to see if we couldn't get it into what we call thermal runaway, which means for lithium-ion batteries, and they're using a particular chemistry that's different from what I've seen before. It's a lithium ion phosphate-based battery. And they exposed that little battery to temperatures 243 degrees Celsius, I put in my notes. That's 469 degrees Fahrenheit, my rough calculations. So that little cell and a wraparound heater was put on it and exposed it to that much temperature, and they got it to go in the thermal runaway, where it's generating its own heat, generating its own smoke, but it would not flame. Then they took it and put it in a cluster of batteries, and they exposed those heat to that cluster, to the module. They took that up to 500 degrees Celsius, 932 degrees Fahrenheit by some calculation. They've got some of the cells right next to it to also overheat, but no flame and no propagation throughout it. And I was truly amazed at how did you do that? Why don't I see that all the time when I study the battery chemistry? Turns out these people, Trina, that designed this, put in an absorbent layer, a thermal absorbent layer inside the equipment. I said, well, that's very, very smart. That's what I would want if I was going to be right next to this facility. If I'm going to live nearby, I want to make sure each and every module absorbs heat and does not propagate, does not make the flame go bigger and bigger and further, and we get this chain reaction. We don't want that. We don't want that at all. So the fire testing was extreme. To get the UL listing, they even took an entire container and once again got into the process as best they could to overheat the entire container, get it to burn. Really unusual circumstances for the entire container. And they couldn't get the next container to catch fire.
One of the questions, and you had made reference to it briefly, has to do with thermal runaway. And thermal runaway, before we see any flames, creates a mixture, if you will, of noxious gases that I wouldn't want to be exposed to, nor would I want anyone exposed to. Not a firefighter, not a resident, not someone who lives within 200 feet of the property. So I'm concerned about that, and you can do all the testing that you'd like to make it flame, but what do we do about that?
Excellent question. You're taking me in the direction I want to go in. So I pulled the studies from Mr. Brown's company, from Trina Storage, and asked them, when you're doing all these different tests, what's coming off? What are we generating? And they gave me a list of gases, top to bottom. So what's the most prevalent ones? The top three were carbon monoxide, toxic. Got to be very, very careful with that, with generators in the home, with fireplaces in the home, anything with open flame, carbon monoxide. Carbon dioxide, which we exhale, and then hydrogen, simple elemental hydrogen. It's a lighter than air gas. We expect that to dissipate very quickly. I asked Trina, how close can I be unprotected to one of your containers, just in a casual sidebar conversation? He said, don't be any closer than 50 feet. Okay, 50 feet. We had 2 PhD scientists within our organization at Jensen Hughes do me an exact plume study. It was paid for by the client. How far do the gases go? And they said, well, we'll take a reading from, projected reading using computerized modeling from 0 feet up to 10 feet in the air. And they said 61 feet was the result they came back. If you're within 61 feet of that container, it's burning, worst case scenario, then you're going to be exposed to what would be unhealthy levels of off gas. Now, the
And
national
before it goes into flame, we've got gases coming out.
gas is coming out, no flame yet. The worst case scenario, 61 feet is what they came up with. And I believe that report will be made available. Am I right on that? Okay, so
Part of my concern, and I know you'll have some more information to share with us, the testing that your firm has done was paid for by the client. And we know that a lot of research today is paid for by clients who are seeking a particular outcome. So I'm questioning the integrity of the research being done based on who's paying for it and what the end game is. So as a firefighter, as a professional, I'm asking you, why should I believe it?
well, first and foremost, because it's published and as it's submitted to you, it becomes part of the public record. What we're doing is we're putting the entire Jensen Hughes Fire Protection Organization, the largest in the world, on the line. The reputation is there. The professional engineer that wrote this has a PhD. When he was done writing and developing it, he sent it out to another PhD to verify the information. Based on the data we have, it's computer modeling, not actual fire testing. Fire testing was done by Trina. We're taking that information and saying, how far does it go? How bad? How toxic would it be? And that's where we're getting it from. So everything is based on other bits of data, but the integrity of the entire organization, the largest fire protection organization in the world, says this is the approximate area where from 0 to 10 feet you'll be exposed to levels of gas which will be unhealthy. And they actually describe that in the report.
But you're still relying on data that you obtained from Trina?
Yes,
Okay.
that is correct. We can't do the independent studies they have done at the level they have done, which is incredible. I will say that the NFPA and their standards, excuse me.
You don't know what that is, but continue.
It's a bug. So in the 855 standard, it says 75 feet. What we put in the emergency plan was 200 feet. You hear them refer to that over and over. Why 200 feet? Because that too is a recommended distance for evacuation of the general public. They should not be within 200 feet of that. We said, well, if the general public should be back 200 feet, I want my firefighters back 200 feet. Now, if they want to go closer, be my guest. But I want you wearing full protective gear, top to bottom, and self-contained breathing apparatus that's positive pressure. Because we're going to treat them like anybody else as far as their lungs or their opportunity to be exposed to these gases. Now, some of these gases are lighter than air. They're not going to travel very far as impinging at 200 feet or being a concern at all. But we're still going to protect them. I will admit that one product, hydrogen, that will be given off, is a gas that can be ignited. Hydrogen, we even in some cases are powering up buses and other tools, other vehicles with hydrogen gas. It is a flammable gas. However, they engineered into the system a detection system within the container units. They put in heat sensors, smoke sensors, and gas sensors. And when those things get activated, what happens is they turn on exhaust fans. So what we're trying to do is make sure we don't get enough gas collected to have any kind of issue. In other reports I study about fires that occur in BESS containers, I'm seeing a buildup of unburned gases and then an ignition. Here, the engineering is as such that they're looking for that. So as time went on, they got better and better and better. They engineered some of that concern and reduced it. So I'm very impressed with the engineering on this.
You had mentioned that you wouldn't want a firefighter within 200 feet of this. And if they were, they'd have to be suited up appropriately and so on. We have people here who live within 200 feet. They're supposed to suit up when there's a problem?
Well,
what happens?
Well, we looked at the distances, and I put it in the emergency plan as far as who's close by. And we found no homes within 200 feet. We're probably, and I could actually pull the manual and look, some of the distances were more like 650 feet from the BESS site.
From the actual BESS facility.
Yes.
Right, not from the
Fence line, but from the
subject
actual
property, but from the BESS facility itself,
Right.
which I'm sure was cited where it is so that you can meet that standard.
Yeah, the greater the
But
distance.
we have a standard to protect the safety of our citizens, and we're looking at this site specifically as you are, and asking ourselves, is it safe for them? Is it safe for a community in an area where we have infrastructure that we all in the entire county rely on? And and we will ask you to continue and give us some assurances. But we look at this site as particularly questionable as to whether it should be evaluated as a potential use for this. That's where I'm at. I'm not sure, I won't speak for the other board members, they're entitled to their opinions, but I know that if you can provide some additional insight into that, that would be helpful to us.
Well, thank you very much. Looked at those distances, and I looked at the PA standard. Coming off of this. Same thing I would recommend to them when it comes to fighting a structure fire. Should not even get a whiff of the smoke. None of that's good for you. And we more and more and more cutting that out completely, 200 feet. What it would like to do is transition into strategy and tactics for firefighting. Is that acceptable? May I transition?
Yes, please.
Well, I have one question. The battery technology that you assessed here, that was the lithium iron phosphate?
That's correct. Lithium iron phosphate, as they have constructed their units and how they put them together, and the case they put them in, all that was considered.
Okay, and then should I be looking at other BESS systems with lithium iron phosphate to be sort of comparable systems in their real-world application?
Yes, and that you made an excellent point. You're stealing some of my information. I've looked at other best fires because there's always that. Said, okay, now, what was the chemistry of that particular battery? How was that module installed? Tell me about the building. For example, we had firefighters that were injured in Surprise, Arizona. Horrendous. Want that? What happened? That type of facility was you could walk into, and the battery units were inside a building you could actually physically fit into. The batteries overheated. They were generating smoke containing the hydrogen gas. They waited. When they opened the door, it provided oxygen to the situation, and the gas ignited, and they were injured. These containers we're looking at, as I said, there's no space for you. So if I was saying your lithium-ion battery in your laptop computer was catching fire, you can't put your hand inside your laptop computer. There's no space. It's all wires, it's fans, it's cooling systems, it's electronic reporting and monitoring systems, it's batteries, modules themselves. There's no space for a person to fit in there. And if any smoke generated, they get to those issues secondarily. The fact is, they want these batteries to make money. They want these batteries to take in power when it's cheap and put it out when it's more expensive. We have a peak demand. What I'm seeing here is they're tracking each and every battery, how it's performing. If it's not performing, if it's overheating or it's just not taking charge or some issue, they don't want that in their system. They're going to pull it out. These things have a really good life expectancy. So the next maintenance cycle, it'll be turned off remotely. They can come out and pull that and put something good in there, even before it goes bad. I will tell you, with all the electronics I have and all the batteries I have, I put it on the charger, I walk away. I don't think about monitoring remotely. I don't think about testing the air above the charger for my lawnmower battery. This is what's going on here. So I find it to be very comforting, but we still need to be overprotective as far as the procedures for emergency response. Did that satisfy?
It does. Are you familiar with the Warwick fire in New York?
I am not familiar off the top of my head with the Warwick Fire in New York, but I'm going to look to my notes.
Yeah, though, as I said, we've submitted a report addressing the Arizona fire. There were a few others raised in the Environmental Commission report. We're preparing a separate study on those that we will be providing to the board and to which Mr. Dianarine will be testifying.
Okay, 'cause I bring that up because that was a lithium iron phosphate system.
Yeah.
And we,
No,
just
we're-
a note for our time schedule. We wanted to accommodate your witness, and we appreciate your testimony. I would want to set a time limit here of 10:15, so if we can go to that. You may have to come back, but it seems to me you're
Of course.
clocking the frequent flyer miles, trying to get on the docket as it is. So if you don't mind, we'd appreciate that.
Could I ask a question?
Please.
Would you be comfortable having your mother at a senior citizens facility that's about a quarter-mile away if this were to go into catch fire, or to take your kid to a baseball game at a minor league park a little further down the road?
Personally speaking, answer is yes. It's a big hypothetical. So I'm the father and stepfather of 7 and grandfather to 10. And I would tell you that I don't have any major issues with visiting some of the nearby facilities that are here. There's like active disposal down to the south. So if we were going to take a tour of that, or the Somerset County facility, and there was an incident there, we might watch, and I'd recommend, there's nothing to see here. But I'd probably be more worried about the ball game example of, I have one or more electric vehicles on fire in the parking lot, where I want it being close, and they are exhausting a lot of toxic gases, a lot of high heat and such. And as we look at other lithium-ion battery situations, which do not equate to this particular situation, we've had car fires at, I think, a parking garage for an airport in Florida, in which it just took off, and they lost most of the parking garage. A lot of cars were burned up because of the amount of heat coming off of the automobile lithium-ion batteries, which don't get all the protective measures, aren't protected from impact, aren't protected from being overcharged. In the Warwick example, I know we'll probably get into that in future testimony. I will let you know that part of that is caused by water intrusion. And here we've been talking about elevation, we've been talking about drainage, and the Trina, once again, they put legs on the containers. The containers don't sit on the ground. They actually have like a pipe type of leg underneath of them, once again, to prevent water intrusion, and the containers are watertight. Just like you'd have a tractor trailer going down the road, if it rains, we're not worried about the contents of the tractor trailer getting wet.
If water happens to intrude on the air conditioning or heating system, what happens to the battery?
Well, everything gets shut down. Yeah, there's a water sensor been built in here. As we tore at this to look for problems, we kept finding that the engineer had gotten ahead of us in the design of the equipment. Now, we'll keep poking, keep looking, but I want more systems that are over-engineered to be used in general. I look back to a lot of the different situations and see engineering problems. Now, we've advanced. Even the New Jersey code is more advanced than the codes that were used at Surprise, Arizona, in which we're 6-8 years more advanced, and we're getting tighter and tighter. And different states have also very tight regulations. So I digress to talk about regulations and regulation development. I'm going to touch on firefighting, and then we probably run out of time. So here's my advice to the firefighters. Arrive on scene. Open the gate. Hook up to the hydrant. Get a lawn chair. That last part was very important. I'm sorry for being a little bit flippant. The batteries are designed to burn out. It's going to get hot. It's going to overheat. The fans will come on. They even have a built-in suppression system. If it wasn't the battery, let's say it was a fan or a fan motor or some kind of piece of wiring that burned, they put inside the container an aerosol firefighting system called Statex. It's non-toxic. It's very, very effective for putting out fires. So that system will fire off, and any kind of wiring fire is taken care of. Remotely, they will see there's a problem, and they'll turn off that unit. So why would I want firefighters to get up close, because getting close does not fix the problem. Spraying water on the container, which is an insulated container, will not cool down the batteries. Spraying water in the air on adjacent containers. In the full-scale fires that they built and purposely overheated, when they burned one container, not enough heat generated to set off another container. Flowing water will just give us an erosion problem. So I'm telling them in their plan, do not fight the fire. Show up, make sure people are back. Like I said, get your lawn chair out. Do not be flowing water. Now, I agree in firefighting foams. I have a lot of experience with that from industrial firefighting in chemical plants and refineries. I was responsible for 38,000 gallons of foam concentrate. And we mix it at about a 3% concentration with water. Great for flammable liquid fires. For these fires, that water will never touch the battery because it's inside a watertight container. So the spraying is mainly for public appearances. But you should not be making strategic and tactical decisions based on what it looks like. It looks like we're doing something. They shouldn't be doing that. They should maintain their safe distance. The number one response to that site will probably be something where a slip, trip, and fall, stung by a bee, something like that. Worst case would be a brush fire or grass fire. But as I hear the civil engineer talk about they're getting rid of the grass being up against these things, they have crushed stone underneath, it's really taking away a lot of my concern for what could go wrong, what could happen. In respect of time, I'll take whatever questions you may have.
Sure. All of our firefighters in Bridgewater Township are volunteers. So there are no paid professional firefighters. When you go beyond the scope of Bridgewater, because there's cooperative agreements among the fire departments to support each other, I'm sure you're familiar with that, they're also all volunteers. And all volunteer fire departments are there to serve the public. They want to protect the public to the best of their abilities. And we're asking them, and they volunteer to run in or toward the fire, as we learned in incidents like 9/11, while everyone's running away. So when we ask them to come and you're telling them to sit back, that's their natural inclination is not to do that. So the question becomes then, who is responsible for A, training them, B, the expense for training them, and then C, for ensuring that they behave appropriately to that training?
You're exactly right on the aggressive must do something, must extinguish attitude of firefighters. And that's a blessing, really fantastic. We need that during structure fires or any fires where there's occupants inside. And they're going to take great risk. I would ask them to be risk evaluators. To begin with, what they paid for is for me to study the situation and write them a book and then share that book with them. And then I've already met with a group of fire officials that had lots of concerns. And I sat down and said, okay, I hear your concerns. Let me show you what I recommend you do. I know that from interviewing Mr. Brown, who's sitting back there, that they provide training prior to commissioning of the equipment. Basically, if you wanted to put a stipulation, it's your right and privilege for training to occur before that you want to mandate, great, or annual, great. Love that because there's turnover in the fire department. But I agree with you. Training is essential for the protection of the firefighters. We need to make the manual available to them, which they've had for over a year now. We need to have on-site training and repetitive training to make sure we protect them. I would also point out there's a substation just off the edge of Bohemus Lane right there. If they ask me, what do I do with that? I would say, got your lawn chair? Do not flow water on the substation. Do not flow water on the high-energy power lines. Do not flow water. That will burn out. Let them kill the power. Let it cool down. The transformer go out. Do not attempt to fight a transformer fire. I'm off topic, but I think some of the training on aggressive tactics, and sometimes we have to use really the logic part of our brain and say, this is one of those situations where we protect and we stand back, protecting even our fellow firefighters.
And I appreciate that view. I will say as well that with respect to two things you mentioned, one was the meeting that you had with some of the fire officials. That's been a sore topic for us because none of our board professionals were privy to that meeting. So some of our questions may be those questions that you had asked and answered previously, but we want to make sure that we have the benefit of that conversation and that's why we may pose some of those questions. The second thing is that with respect to the substation, which is right across the way and will be a point of discussion in the future, we are dealing with a public utility there that has a much higher degree of regulation imposed on them and a whole host of government agencies that they need to respond to, which will not be true in this situation. And they are providing us a higher level of security as a result. But with that, we're just about at the end of our allotted time this evening. So I'm going to pause and look for some additional time for us to meet. Ms. Probst, any ideas? I'm sorry, you said September?
October,
Oh, I see.
and October 27th would be next available.
October 27th.
So is anything else scheduled for that evening right now?
Not right now, no.
My best guess is we need a whole night for him, and honestly, maybe two. Just anticipating the questions that are coming at you. So we should do our best to try and keep it for the whole night. I know we tried to do that this time. Sometimes things happen, and, that we had to fit that in. It was half an hour, but we stayed an extra 20-something minutes, and so we kind of made it up to you. So, right, so maybe we could just try and mark that to keep that for the whole night.
Right now, they are the only application on.
Yeah.
It's really up to the board and their discretion as we have applications that continue for the next few months. So we will leave it open as best we can, right, so that they are the only applicant. If anyone else makes that request, it's up really to the board, the chairman, to determine if they want to allow them to split the night. We
Right.
get this request all the time, right?
Right, I know.
So we will try and keep it.
Yep.
We can get through it.
Yep.
We will.
Okay, so for purposes of the public, this meeting is concluding now. It will continue on October 27th at 7 PM in this room, and there'll be no further notices from the applicant. Okay.
Okay, let me
Always
just,
check with Nancy, though. Okay.
Any housekeeping matters? We all set?
Just would like to ask Mr. Pantel if he would extend time to October 31st on the record, so we don't have.
just let me just check that October 27th date for a moment, please.
Sure.
We're good? Sorry, we should have checked with you. Okay.
One thing I do want to add is that meeting that Mr. DeHonorine alluded to, attendees did actually include Bridgewater's Deputy Fire Official Xavier Alvarado, your Director of Municipal Services, Tom Genova, the Finder and Assistant Fire Chief, Tom Rusetta, as well as some Somerville representatives.
Yeah, and I know your letter, Glenn,
We're not trying to
said
do any
that,
run around anybody, and it was arranged through your office of the zoning board with invitations to Mr. Scalera, et cetera.
yeah, and I know your letter indicated that Maria did it through the zoning office, but I understand she's Mr. Scalera's secretary, and it was really set up through his office, not so much through the land use department. Nonetheless, we have him here. We're going to go through all those questions, memos, reports, and you're going to have the meeting a second time, okay?
No problem.
Okay,
Okay.
Thank you.
thank you.
With that, can I have a motion to adjourn?
Chairman, if I could just.
No, please go
before we
ahead.
adjourn, any resubmissions, barring the 10-day statutory requirements for something like this where we want to give everyone adequate time to review, can we ask, or we would ask that anything that's being submitted for review would need to be on file at least 3 weeks prior to hearing.
We can't require it, but we're requesting it.
Understood.
And a transcript.
Yeah, we've been providing the transcripts.
Yeah, did we get one from the last hearing? Do we have?
Yes, we did
I
provide one. for
believe
the last
so,
hearing.
yeah.
Okay. Can you send it to me, because I only have the first one?
Yep. And we'll get
confirm
another
we
one
have it.
from this
Okay.
meeting.
Okay.
Not a problem. So we're.
You don't have it either? Oh, not, okay, all right. So, together we have the whole thing.
Exactly.
So we're going to adjourn to October 27th with no further notice.
No further notice, October
7 PM in
27th.
this location.
Yes, the announcement's been made. You then verified you're available, so I didn't have to do it again, so yes.
Right.
Okay?
Thank you very much.
Okay, thank you.
Okay, good
We'll
night.
take a motion to adjourn. Second? All in favor? And motion is carried. Tell me about